Yes, Mr. Chair.
Met with Lordship. Item number 50, my lord, this is of course, you may appeal, and the lady is there for last 2 years. But my junior has left her outside today. So can it fix on my lord, matter bit urgent? It was brought on our request on 3rd of April.
3rd of April may not be possible because prior Eid and prior Bihu, there are lots of matters have been fixed. So,
Moreover, CD
will-
is there, Lord.
Huh?
CD is there. 55.
no, he is on 50, I think.
50.
505.
Sorry.
It is a cabin material.
So will it be preferable if it fixed after Bihu? Because prior Bihu also matters have been there, in fact.
Then my lord, we will have to fix on 22nd.
22nd. 22nd. Okay, yes, 22nd.
I think item number 45.
Senior advocate assisted by whom?
My name may remain.
Huh?
My name may remain.
You were assisted by whom?
Saurabh Dhingia. Yes, Dhingia.
As Dihingya.
Yes.
Okay, thank you.
My pleasure. I need to mention item number 45. As per the office note, service report awaited. It will come after vacation.
45.
45.
In this case, CD is there, Lord.
You have received a CD. CD in a sense, it is a in
Also maybe.
No. IT was
no, whatever you have received the CD. CD is in scan copy or original?
No original. Lord. Not may I look into.
Yes, just he is saying service. Scan copy.
No. It is not scan.
It's the original one. So better to return back ID
Return back, Lord.
because service is to be awaited.
Lord.
Please note, service is still awaited for response number 2. However, it is submitted by Mr. Das that
But I only want to state here, Lordship, that 2 CDs are called for. 353 Lakhimpur from Lakhimpur itself and 346. Here we have received only 353.
350.
Case for the same set of allegations, 2 FIR has been lost.
Whatever, if
They
it is
come here for
already
the
called,
subsequent-
then definitely. So we have received 353.
353.
Other one not to rakhi given.
Uh,
Other one, other
346.
346 of 2000.
24.
Both
Both 24. Lord.
24. Both submitted that CD of what's case number? PS?
353.
No, PS.
Yes, Lakhimpur.
Lakhimpur PS case number 353 2024 has already been received. But the Lakhimpur PS case number 346 2024 is not yet received. Issue reminder accordingly. Further, the CD of so and so also be returned, asking directing the IO to produce the updated one. Service for his response number 2 be awaited till next date of listing. List accordingly after 2 weeks. Okay, it will be listed. Interim was there after 2 weeks. Interim be continued till next date of listing.
May I please, Your Lordship. In item number 53, I have filed an additional affidavit, which is not on record, Lordship. Can it be placed in?
In item number
53?
you have filed.
Yes, Lordship. Yesterday.
Okay, we call it
Yes. Okay.
53. Huh? Item.
Wait, please, Lordship. Like to mention item 38, Lordship. 38. Lordship, case day is not available. Lordship, may fix another date for it.
Yes, 38. Not available. Are you on interim?
I'm on entry.
Interim be continued for you.
Lordship, here, Lordship, charge sheet submitted, Lordship.
Oh, acha.
Charge sheet submitted.
CS submitted.
Yes, submitted.
Okay. So your interim will be extended by
Extended.
today up to 15 days you want?
15 days.
15 days interim will be extended and CS number, yes.
Number is 24/2025 and dated 22/03/2025.
Okay. Okay, will be extended. This was for you.
Okay, hold on. Yes.
Okay.
Please.
Did it is such a one?
Lordship. Criticize
204 days behind the bar lordship. So it's there.
It is in motion column, but one order was there, na? In 3-3, on 3-3, one order was passed.
Lordship.
Hmm.
Record was called.
So one report was called for from the trial court regarding the status of the trial. This is POXO so and so, it's true. You have received the report
No.
as
From
per
trial
your
court-
instructions? Yes.
Trial court then lordship registry will receive it.
Oh, just, that's office not will see it. It is received. CD, I mean, scan copy of the case record along with the status report has already been received,
Lordship.
but service is awaited.
Lordship.
Service regarding the
No.
service, the same process you have taken through
Lordship.
judicial police station.
Lordship on 6.
So you may make an inquiry regarding the service of notice. Because person is behind the bar since when?
Lordship, today is 204 days. Since
204
2nd
days.
September 2024.
Okay, and as per your instruction, is there any witnesses are already been examined here?
Lordship.
Part Mr. So going to. The scan copy of the case record along with the status report has already been received. But from the office note, it is seen that the service is still awaited for respondent number 2. In that context, additional SP, Mr. Das is hereby asked to make an inquiry regarding the service of notice to the respondent number 2. List accordingly after 2 weeks or 1 week.
Then was on before Bihu sorted. Otherwise, amicus may be offended, Lordship.
Am I customary? I mean, we are not having received the
Lordship.
service report.
Can we have first
If
week of
we
April?
prior Bihu, it may not be possible. It will be only after Bihu only.
Can we on 9th of April last? Lordship?
I don't think so, because lots of matters have been fixed and those days, bell matters will be also there, other bell matters.
On 10th of April, Lordship. And
No, 9, 10, these are all fill up, in fact. Immediately after Bihu will do, immediately after Bihu.
Is it possible also before Bihu? Only for the service report, Lordship.
Huh?
Only for service related.
Service related. Okay, then 9 will do. Okay, 9.
9th of
Await for service till 9.
Mass Lordship.
2 and 3.
2 and 3, in fact, here notices was issued, they have also filed objection.
Lordship, kindly pass over the matter for time being, Lordship.
My lord, there are 11 motion matters, my lord. I have some preoccupation today. Always I accommodate them. Maybe after item number 11, because till item number 11 is bail motion. After bail motion, this may be called, my lord.
Thank you, Lordship.
Time, both 2 and 3.
Item 4.
Can you pass over the matter of time?
Time being, that's all.
5.
Maybe Lordship. Lordship, in this case, FIR is page number 9, Lordship.
Since when he is in custody?
Yes, Lordship. Lordship, he has been arrested on 12 to 2025, Lordship.
Hmm.
And today is 42 days. Allegation, there is section 6 of POXO, Lordship.
Oh, section 6 POXO.
Yes, Lord.
Notice has to go otherwise.
Yes, sir. Lordship, CD may be called along with the medical report.
Okay, you take steps for issuing notice to the respondent number 2. That is the route will be through judicial police station, routed to the office of the registry and the public prosecutor.
All right. Lordship, next date,
Next date,
after 10 days,
hmm?
after 10 days,
I don't know, it will be reached by this one or not.
Morigao,
It has to come from Morigao.
Morigao.
CD along with the medical report. 20. 20.
It's
28.
It will be late,
28.
Lordship, it will be low. 10 or 12.
10, 12, 12 from 12 to holiday.
But it is no so far distance, Lordship.
No, matter is not that. Question is that prior Bihu and prior Eid, we have lots of matters. That is the question.
Okay.
Otherwise, we don't have. It will be immediately after Bihu only.
121.
21, okay. 21.
Oh, yes.
Kanaka also.
Item 6.
Near page, your lordship. Lordship 483 DNSS application, your lordship. The cases of human trafficking, your lordship. Now, lordship, the petitioner, your lordship, along with a 2-year-old child behind the birth, more than 28 days, your lordship. So, your lordship, CD may be called for. In this occasion, your lordship, I have a prayer, lordship. So, this short date may be fixed, lordship. 2-year-old child is not too well, your lordship, in the prison, your lordship. So, can it be, lordship, lordship, for Friday, your lordship?
Which Friday? This Friday?
This Friday, your
Not at all
lordship.
possible. Not at all possible. Something you are finding it, Mazak. Bihurago. Why don't I people?
9.
9. Yes, 9 and 4.
Lordship.
Okay. So,
7.
Lordship, it is a regular bail application under section 22C, 25 and 29 of NDPS Act. It is a
Charge-sheeted case?
Yes. Call for the HCR.
answer will call for. Next, you will do the needful. Scan copy of the answer along with the case diary. Do the needful. List accordingly after 2 weeks. It will be listed after 2 weeks.
Item 8.
Your lordship, it is also search-sheeted matter.
9 also, same.
Same.
I mean, NDPS.
Yes, your lordship.
Since when he is in custody, can you tell us?
He's arrested on 12/12/2023, almost 1 year, 3 months.
Here we are fixing a date, 22nd of April.
God bless your lordship.
Scan copy same of 22nd of April.
Item 9.
My lord, this is an application under section 483 of BNNS. In this case, my lord, the petitioner was arrested on 2/11/2024. And last 144 days, he is behind the bar. He is a mason by profession. And since the fact is like this, since 1 year back, he has love affair with the victim. But as she is only 16 years of age, he told her that when she will be mature, he will marry her. But in the meantime, she developed some relation with other boys, and accordingly she got pregnant. And her family insisted him to marry him. But as he refused, quarrel took place on 1/11/2024, and affair was lost.
It is charge-sheeted already.
Already substituted, my lord. In order to defend himself, my lord, he is to be he is to be released from the jail, my lord. How he will defend himself? And no, the POXO is there, my lord. It is true, but no DNA test is not yet done.
Whatever it will, everything will be revealed after perusal of the case diary or this case record.
My lord.
So, and the question is that it is a POXO, section 6 is there. So
6 is
you
there,
have to issue notice to the respondent, number
Yes,
2.
yes, that I know.
Through a judicial police station, routed to the office of the registry and the public prosecutor. So that is the process. And by that time, we also call for the scan copy of the LCR along with the case diary.
My lord.
It
Yes,
will be-
it may be given, my lord. Already he is behind the bar for 100.
Short date will not serve your purpose because notice has to be issued and it has
Yes,
to
yes.
be returned. So such a short date will not be beneficial. Otherwise, again, it will be awaited for service of notice. That is the issue. So we are scanning for the scan copy. After 2 weeks. It will be after 2 weeks, then
Yes, yes,
then
yes.
after Bihu, it will definitely
Yes,
come.
yes, my lord. But
After. Same order. no?
kindly say a date may be fixed, my lord. Otherwise, it will not come.
Whatever you can come or not come, we don't know.
Kindly a date may be fixed, my lord.
পরিবার এলাকা তো পাগল হয়ে যাবে। কি কত 23/4
Obliged, my lord.
Item 10.
May it please your lordship, here also my child marriage and POCSO is there, my lord. Lordship may issue notice, my lord, fix a date, my lord. Father and son both are behind, child marriage is there, my lord. Father and son both are behind the bar.
Yeah, both are father and son.
Son, my lord, child marriage, my lord, marriage took place long back, my lord, now, my lord. After all, POCSO is there, lordship has to issue notice, my lord, but otherwise there is no case, my lord. Because marriage took place earlier, my lord, now he is arrested, but POCSO is there, my lord. So, lordship may fix a date, my lord. And notice me through the police station, my lord.
Yes, when can it be fixed? When it can be fixed? 23/4. Same order. Okay, you text it within 2-3 days.
Lordship, obliged.
11.
Section 4 POCSO. This is section 4 POCSO. None appears on call for the petitioner. List the matter accordingly after 2 weeks. No, by the way, this is the charge sheeted or not yet charge sheeted?
Not translated, I think.
Not.
I
not
think
yet.
lordship, because it is not there in order is not there.
(22/01/2025) he got arrested.
No.
So we can list it after 1 week only.
No, no.
A list after 1 week.
51.
51.
May it please your lordship, in this case, we have to file the additional affidavit regarding the charge sheet number, your lordship. Lordship, charge sheet have not received yet, lordship. Can it be fixed on Friday?
At the time of filing the case, it was within your knowledge regarding the filing of the charge sheet.
Yes.
But why you have not collected the certified copy of the charge sheet at the time of filing also? Okay then, heard MS,
May the lordship.
MAD, the learned counsel for the petitioner, and also heard Mr. KK Das, the learned additional PP, appearing on behalf of state respondent, which is submitted by MS Medi, that some time is required to file their additional affidavit to bring the charge sheet in the record. Prayer allowed, list accordingly. After 2 weeks will do.
Can it be before Eid, your lordship?
No, before it's not at all possible. Before prior Bihu, maybe I don't know, 7-8 kilo fine. 8 is holiday or open day. Many cases. What to do? We don't have any space in fact. But he is in, it is a charge sheeted one, na?
Yes, your lordship.
What kind of case?
Postco, yeah, there is lordship.
Then after Bihu, kori list after Bihu.
Lordship POCSO that issue notice.
Lordship,
It was, I don't know, it was already, oh, acha. On the last occasion also, your prayer was considered and you are directed to file the additional affidavit. But till today, you couldn't.
No.
After filing of the additional affidavit, you want to file your things and all. What? Because additional affidavit copy has to go, na? That's what. No. Okay, then after Bihu only. 25.
lordship.
Lordship, I have a prayer, Lordship. Lordship, I am for 11, Lordship.
It's 11 already passed.
Just one prayer, Lordship. Lordship, there is another case, Lordship, same FIR, Lordship. Does both the matter come up together, Lordship? For 11, Lordship.
I don't know. What's the other number?
Lordship, 685, Lordship.
685 of 2025.
Yes, Lordship.
List according after 1 week, which 685 BA or that is BA or AB?
This is BA, Lordship.
BA 685 only 2025. Okay.
Obvious.
Item 12.
Lordship, 685 matter is in tomorrow, Lordship.
It will be listed after 1 week, not tomorrow at all. Other matter is fixed at tomorrow.
Yes, 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 yes.
Okay, then list along with so and so, it may come.
Yes, yes. Oh, bless you.
12.
12.
Please, Your Lordship.
Yes.
In the revision petition, my lord, in this matter, my lord, petitioner is the second wife. Lordship, the petitioner first wife is the respondent number 2. Respondent number 2 and husband of the petitioner was got married in 1998, my lord.
Mm.
And he's out of their wedlock. They have no issues, my lord. And she's respondent number 2 is also a mental illness, my lord. That's why the husband of the petitioner decided to adopt a child. The child was the petitioner's child, lordship. Petitioner is a widow, and that period of time she has a 3 years old child. And the respondent number 2 and husband of the petitioner decided to adopt her child. And as a minor 3.5 years old boy, they decided to adopt the child and also decided to marry the present petitioner as a second wife. The respondent number 2 also supported for that, lordship. Thereafter, in the year 2014, she got married. Petitioner got married to her husband. And that year itself, lordship, the petitioner respondent number 2 left the house on her own volition. And in the year 2015, she filed a petition before the learned court below under Domestic Violence Act. In this petition, my lord, the learned court below directed to take shelter of accommodate the residential order passed and also passed the 5,000 rupees monthly paid to the respondent number 2. Lordship, as per the order, the husband paid the 5,000 per month, and see what was done by her in the part of respondent number 2. She, after getting the order, her 2 rooms with her furnitures put on that room and keep the room lock and key and left the house. In the meantime, what was happened? The petitioner number 1 and husband, second issue was in the year 2017. Their birth certificate is also here. All of a sudden, in the month of May 2024, the husband of the petitioner died. At that point of time, she came to the house, and last 10 years, he did not visit the house where the petitioner and her husband is residing. What happened after when he died? She came for 2-3 days, he stayed and left away. And thereafter, after 1 month of his death, she again filed a petition before the learned court below in connection with earlier case, 2015 case, and got an order. Lordship may kindly see the order. This is the page number. Page number 33. CR case number 53 of 2024. In this order, my lord, lordship may kindly go to the last para. As it is clear, may I read, my lord? As it is clear from the report of the protection officer with regard to the spot verification that aggrieved party has not been able to stay in her own house due to inconvenience caused by accused Sutumani Das, this is the present petitioner, and that aggrieved party is not even getting the house rent as well as shop rent of her own property. Hence, I deem it fit to direct the protection officer to accommodate shelter to the aggrieved party immediately in her shared household, as was directed by judgment and order dated 10/1/2018 in connection with CR case number 122. Then protection officer came to execute the order and in completely inhuman manner ousted the petitioner along with 2 minor sons, my lord. Thereafter, she came to the court by filing a petition. It is the page number 37, present petitioner. And in this petition, she stated her grievance and in the prayer directed to stay in her house along with her minor child, as she has been staying in the said house since her marriage, that is from 2014. Lordship, thereafter,
page number 39. In my petition, the learned court below passed an order dated 18/2/2025. It is a long order, my lord. Lordship may come to the page number 41, operating portion. May I read second para? Upon it, thoughtful consideration to the submission advanced by both the parties and on an assiduous scrutiny of the materials in record and documents submitted by the accused Sutumani Das, the court is primarily satisfied that she, along with her children, was evicted from the shared household without following the due procedure of law, and she shared domestic relation with Dhananjay Barua since disease, and as such, she requests to be restored in the shared household along with her child without disturbing the possession of the complainant aggrieved. It is the respondent number 2. Hence, I deem it fit to direct the protection officer to accommodate shelter to the accused Sutumani Das and her child immediately in the shared household without disturbing the possession of the complainant aggrieved. After passing this order, before going to the protection officer to hand over to possession of the her room, to shelter of the her room, they have filed an appeal before the learned session judge. The learned session judge, without perusing the case record, as it is a domestic violence act, all will be cleared from the trial evidence. The learned session judge had ordered the 20/2/2025, this is 14/9, state the order of the order dated 20/18/2025. The order, it was passed by SDGM M. It is not a bad order because considering both the parties, and in fact, my lord, since Bihu, my lord, Mag Bihu, she took shelter in the house, veranda of the house with minor child. They have completed their examination by staying in veranda. They have not yet took their books also. My humble submission before your lordship, as it is the order 18/2/2025, it is supporting both the parties. My humble prayer before your lordship, my lord, this order may be remains and the appeal filed before the session judge may be directed to dispose of within a stipulated period of time.
What is appeal has already been admitted?
Admitted, this is tomorrow is the second date. So far, my information goes, as they have already got the stay order, they have not yet taken step for notice.
But you can appear.
Lordship, I can appear, but so far as my condition is concerned, my lord, a lady who
No, it's okay, but you
Lordship.
can appear. You
Lordship.
appear before the court and also insist the court to proceed with the hearing first, appeal. That can be done. Otherwise, it's a, and here your prayer is that the appeal should be expeditiously disposed of.
And for that period of time, may be allowed to at least one room to stay. The
No,
petitioner.
without anything, how can I pass that order? One room is a.
Lordship, because my submission is that 18/2/25 remains, will be remains. If your lordship will pass that, the order.
18?
18/2/2025, the SDGM's order. If this order remains, that nobody will suffer. Because
How it will remain? Unless it is stayed, it cannot be remain. How can it be? It cannot be. 18/25 order was there in your favor. Whatever, against that, they preferred an revision. Sorry, not revision, appeal.
Criminal appeal.
When the question is that appeal, now see, if you go by this order, it is purely an interlocutory order. It's not anything is there or nothing has been decided here. So that is one aspect. You have filed your revision petition against an interlocutory order. That too. But however, I can just pass the order for your convenience that the matter may be disposed of. Your submission I'll record definitely. And it may be mid-direction, but stay of the this.
Lord, sir, what problem we have faced, my lord? The trial court's record already called for. Then automatically this proceeding is stopped.
Yes.
This problem is all I faced because all will be cleared from the evidence of both the parties.
But the question is that now what to stay? There is nothing. In fact, 2002-2025 is filed against the order of the 18-2.
18
So now 18-2 is not before us. You are challenging the order of 22. So
Lordship.
without hampering this one, we cannot pass an order of 18-2 unless either it has to be stayed.
2011, 2024, we have application against the 2011-2024 order. 24th, this application by 18-2025, SDGM passed the order
Mm.
for both shelter of both the parties. He has
Yes.
come before the session judge challenging.
No,
the
yes, I
18
can understand.
laws.
Now the question is that you have challenged the order of 2002-2025.
Because this.
No, whatever ground you have challenged this
No.
one, though. So this is purely an interlocutor, nothing has been here. So this one point, the revision is whether it can be entertained or not, that is one questionable aspect. Now, the another aspect is there, without staying or without hampering this order, we cannot pass any order that it will remain. There cannot be any such kind of order. So at best, considering your prayer, we may pass an order for expeditious disposal. If it is
Time
tomorrow,
may be framed. Tomorrow I will appear and within a stipulated period, the hearing will be conducted. Only considering the lady petition and two minor child.
had MSP Purva, the learned Bora, sorry,
Bora.
Bora, the learned counsel for the petitioner, and also heard MS Mr. Anandas, Kekedas, the learned additional PP, appearing on behalf of state respondent number 1. This is an application filed under section 438, rated section 442 and oblique or 528 of BNSS against the order, impugn order dated 20/02/2025, passed by Dhane District and Session Judge Bojali Patshala in criminal appeal number 1/2025, whereby the order dated 18/2/2025, passed by the learned SDGM M Bojali in CR case number 53/2025 was stayed/suspended.
24 also.
Huh?
53 of 24.
Oh, sorry, 53/24. It is submitted by Ms. MS Bora that the present petitioner is the second wife of the husband of the respondent number 2, and she is the first wife of and respondent number 2, and respondent number 2 is the first wife of her of late Dhananjay Borua. After marriage with the petitioner as a second wife, the respondent number 2 laws and proceeding under DV Act, praying for product protection order of her shared household, and accordingly she was granted with the order of protection. But it is the order that is already earlier order
Earlier, page 26, the
26.
31 is the direction part.
31 is the
31.
direction. No?
Okay. B and C.
Wherein the there the respondent was the husband, wherein the husband of the respondent number 2 was directed to provide accommodations to the aggrieved in the shared household, and further respondents were restrained from dispossessing her in any manner or disturbing in her peaceful position. Apart from the maintenance allowance of rupees 5,000 per month. But during after the said order, the husband of the petitioner and the respondent number 2 died, and thereafter she dispossessed the present petitioner along with his 2 minor children, and and for which the petitioner also had to move an application before the learned court below. 23.
Registered as CR case number 53 of
Which was
54.
registered as CR case number 53/2024, praying for accommodation for their presence, and accordingly the learned SDGM, considering the report of the protection officer and after verification,
Case number 33 is the order.
yes, I have seen. Directed the protection officer for accommodation to accommodate the shelter of the present petitioner immediately in her shared household.
Not
As-
present petitioner, madam,
Huh?
respondent number 2.
No.
20, case number 33.
After that 18/2/25, you are
Not
there,
it.
na?
Thereafter, respondent number 2 opposed the SDGM again.
Again,
In connection with 2015 case.
no, whatever, your petition when it is, it was.
Lordship, after passing the 2011-2024 order, we have come before the court by petition. It is page number 37.
আচ্ছা আচ্ছা এইটো বাদ দিও হিল কাটি দিও তেতিয়াহ'লে সি অলৰেডি অৰ্ডাৰ দিয়া আছে নহয় একমোডেশ্যনৰ কাৰণে
2011-2024 in favor of the respondent number 2.
ঠাণ্ডা দি দুজনী তিৰোতাৰ মাজত গণ্ডগোল হা হা Yes, সেইখিনিকে ৰাখো বাকীখিনি কাটি দিম then court below praying for accommodation of us for to accommodating her along with the 2 minor children in the shared household, and the learned trial court below white order dated 39 as 18/2/2025, directed the protection officer to accommodate the shelter to the present petitioner along with her 2 children immediately in the household without disturbing the possession of the respondent number 2. Against the said order, the respondent number 2 preferred an appeal before the learned district and session judge so and so, wherein without even perusing the record or hearing the other side, had passed the order on 20/02/2025, whereby the operation of impugned order dated 18/2/2025 passed by learned SDGM M. Bojali was stayed/suspended. On the strength of said order, the present petitioner along with her 2 minor children are now staying outside the house and they even could not pursue their we're staying so and so. Books are where the books are there.
Lordship,
Books are
in her possession, madam. Respondent
and
number
all
2.
the other belongings, including the books of the children, are also under the possession of the respondent number 2, and hence agreed to the said order. The present petition has been filed. Next para. MS Borwa further submitted that the said appeal is fixed tomorrow. But to her information, the appellant / the respondent number 2 has not taken any steps for issuing notice to the respondent side. However, after receiving the information of preferring the appeal, the respondent / the petitioner will appear before the learned trial court below, and she accordingly prayed that a direction may be given to the learned appellate court to dispose of the appeal expeditiously or as early as possible, considering the present situation and the circumstances of the petitioner. Next page. In view of this, without going into the other merits of the case and considering the present circumstances as described in the petition as well as and hearing the learned counsel for the petitioner, the learned comma, I hereby direct the learned appellate court to dispose of the appeal number so and so Corridiba pending before pending for so and so to dispose if within a reasonable period. And in the meantime, also may pass some interim order for protection of the petitioner oblique the respondent side if necessary. With the above observation, the present appeal, present revision petition stands disposed of.
Publish.
Thirty,
Yes.
matter may be possible for time being.
There are lots of timing matters. I don't know it will reach or not. Okay, then.
14,
Yes.
My lord, the petitioners, as many as 11 petitioners are here, my lord.
11 number.
My lord. And all these petitioners are relatives of the husband. And
Hmm.
wife has filed the complaint, my lord, against husband and also implicating, my lord, all the near and distant relatives of the husband, my lord. Your lordship may kindly see, my lord. I have
The
come
case
here,
was registered under which section?
my lord, under my lord, it is section under 498A, my lord. Now, my lord, section of 85, that is corresponding to 490, my lord.
Hmm.
118 318 308 subsection 2351 subsection 276.
Case is at the stage, still at the stage of investigation or
My lord,
already charge sheeted?
no, my lord, not charged.
Still investigation.
A complaint has been filed before the
Acha,
Land Court
complaint.
of-
Acha, acha. Cognizance has been taken?
No, my lord. The truth is that. Now, my lord, my submission is that whatever allegations are there, my lord, I am not defending the husband. If the allegations are true, then he will suffer. He will face his consequences. Now, here, my lord, all the 11 petitioners, your lordship may kindly see my lord, page number 9, my lord. This petitioner number 1 is brother, younger brother. Page number 9, my lord.
Hmm.
Petition number 1 is younger brother, 2 younger brother, 3 elder brother, 4 elder brother. All these brothers stay, my lord, in Bengaluru. And this my lord, the alleged place of occurrence is Sribhumi Korimgol. But all the brothers, my lord, they live in Bengaluru. They are businessmen, my lord. Next, my lord, petition number 5, my lord, is the wife of elder brother. Petition number 6 is, my lord, cousin sister, married sister. Petition number 7 is married sister's husband. Petition number 8 is married sister. Petitioner number 9 is another married sister's husband. Petition number 10 is distantly related uncle, my lord. And he's a school teacher serving in government school, my lord. I have filed, I have annexed, my lord, his identity card. Petition number 11 is wife of that distantly related uncle's wife, my lord. She's also a lady. And petitioner number, my lord. So all these brothers, wives, uncle's wife, and a married sister's husband, my lord, have been implicated in the case, my lord. And so far as the complaint is concerned, my lord, I have gone through it thoroughly, my lord. There is no specific allegation against any of these 11 petitioners. My lord. All the allegations, whether true or false, my lord, have been labeled against the husband. And husband is not before a lordship. Only relatives have come before a lordship, my lord, for their protection. My lord. This is my humble submission, my lord.
Complaint means it's a complaint case.
Complaint case, my lord.
So how can you, I mean, filing of the complaint immediately you have come.
My lord.
Cognizance is not yet taken.
Cognizance
Then
has
how
not-
can we say that cognizance will be taken or not? Or what is the stage now? Where is the, you have annexed anything here?
My lord, the notice has been served upon us, my lord.
Huh?
Notice, your lordship may kindly see. My lord, page number, my lord. Page number 23, my lord.
23.
23, my lord. Case number 23, well, the CR case number 05/2025. Tahira Khanam Chaudhary complained versus Makbul Ali. Makbul Ali is the husband and others. And where the above named complaint have filed the aforesaid
You
case.
know, how notice was issued in fact? If cognizance is not yet taken?
That's the fact, my lord. Then how did?
Oh, no. It's a now rule, I think. Now BNSS changed. Yes, that is the reason. That's why notice was issued.
My lord. Notice has been issued, my lord, and on the other hand, my lord, some sections have been here. Actually, my lord, in dowry.
This is so now see, this is a very premature stage. That's just what I don't know whether cognizance will be taken or not, because at present most probably BNSS, I don't know.
My lord,
It was
lord,
under
apart from my lord,
Notice was
498 related offenses, my lord.
notice.
Some more sections have been added, my lord. So we are in fear, my lord.
Notice to कौन section इसी को लिखा नहीं है?
We apprehend, my lord, that we may
Notice,
be.
notice. It is notice under the section di bana lagi down idea of notice to key section this.
Also, my lord, here another point, my lord. There is territorial, my lord, error has been committed by the judicial magistrate, my lord. The alleged, my lord, offenses have occurred in the district of Sribhumi. But this notice or case has been registered, my lord, in the court of first class magistrate, sub-judicial magistrate, my lord, in the district of Kasar.
Now the through BNSS there are some provisions under section 2 from starts from 219.
My lord.
219, 220, 221, how the cognizance will be taken. So at the time of even cognizance, taking of cognizance, notice has to be issued. And after hearing the parties, only the court will take cognizance. So that is the procedure at present, especially in the cases like where the marriage relationship are there, like 498 or 120, whatever. So that is the procedure that your petition is. I don't think it's a stage of filing this petition. I think.
Another thing,
Premature one. This one is a premature one.
my lord, another thing, my lord, the alleged occurrence has taken place in the district of Sribhumi.
No, these are all will come. The court will definitely decide if it doesn't fall under the jurisdiction of the concerned court.
But the
Then
court of Kasar
definitely
has
it will not be taken up. But the question, no, whatever, Kachar or Sribhumi may be there. But the question is that if it is jurisdiction wise, if it is there is not, tenable, that may be, well, within you to raise this issue at the time of taking cognizance even. This is the jurisdiction wise also, it's not under the jurisdiction of so-and-so. Doesn't fall under so-and-so. That can be taken up. But without anything, what to do? There is nothing here before us. You could not bring anything because it's a very premature stage. Only issue notices were issued. Definitely court will hear you, and then only order of cognizance will pass accordingly. That is the case. So how can you pass it? How can you entertain this criminal petition at this stage without anything? She brought some allegations against all the 11, 12 numbers of accused, considering all these. But the question is that whether court will take cognizance in that section, that is the questionable. Now we don't know at this stage. So I don't think it's a case of petty criminal petition at this stage. Either you maybe withdraw this one, praying for a fresh at liberty, or otherwise without jurisdiction or we premature, considering the same as a premature, we may dispose of or dismiss at instance. You think over it. When your date is fixed?
Today, my lord.
Date was fixed today.
My lord, today.
Instead of appearing, you have filed this one.
My lord.
Then what to do? What to do? Better to withdraw, take a liberty to fresh a file because it's a very premature. So it's not, we cannot pass any order, in fact. You are Mr. K.R. Talukdar,
My lord.
the did you with a liberty to, we are allowing you liberty to fresh a file. If you see that cognizance has been taken, or if cognizance is not taken against you, then question of filing the criminal petition does not arise at all. Court may not take also cognizance against you. In that case, if cognizance is not taken against you, then you are not supposed to file anything here. Obviously, husband will be there, or the judicial issue also you can raise. Because all are, some are the distant relative, and as I have said, that some are the elder brother, sister, they are not staying together, I don't know. So, or if there is prima facie no allegation at all against these petitioners, then obviously it may be a case not to take cognizance. That is it. So we are withdrawing this one, liberty to file afresh.
Right.
Okay. Due to technical irregularity, we can pay to withdraw with a liberty to file afresh. Prayer allowed. Okay.
50,
Hopeless.
If this criminal petition is filed against the order dated 2/3/2023,
2, 3,
2/3/2023.
where you have annexed the order.
Yes, my lord. Page, my lord. 29 annexer C.
This is the order.
2/3/2023.
Yes, cognizance taken.
Yes, my lord. His deposition was recorded, my lord, annexer to page 28, annexer B.
Who's the position? The complainants.
Complainant, yes. May I read, my lord?
Okay, we are not going to discuss at present.
Yes, my lord.
Now, whatever the cognizance has been taken, what is the stage of the case at present?
And next date is fixed for, my lord, EBC, evidence before charge, my lord, on 17/5/2025. In the month of May. Kindly see the legal notices. Fire institutions complaint case, my lord. He served 3 legal notices, my lord. One from Delhi, my lord, one from Kanpur, and last one, my lord, Guwahati, my lord. Same subject matter, my lord. Kindly see last page, my lord. Annexer J, my lord. Page 59, my lord. This is the account balance confirmation provided by, my lord, the respondent number 2, that is my complainant, my lord. Kindly see, my lord, account balance confirmation as on 30/6/2022, my lord, and occurrence was took place, my lord, 2017, my lord. In reflecting in their deposition, my lord. And in account balance statement, my lord, balance is 0, my lord. To harass the complainant, my lord, to harass the accused person, my lord, petitioner, my lord, they file the complaint case, my lord. Moreover, my lord, kindly see, my lord, page number 31, my lord. This is the invoice, my lord. I am not disputing, my lord, regarding purchase of, my lord, tires, my lord. But transaction not took place, my lord, entire transaction took place at Calcutta, my lord. Kindly see page number 31 to 35. These are the invoice, my lord. Nowhere is stated that the tire was purchased from the Guwahati, my lord. Their seal and signatures clearly indicated that all the invoices, my lord, issued from Calcutta, my lord.
So you are on bill now.
Yes, ma'am.
So we call for the scanned copy of the case record along with the case date. Obviously, it will be fixed in the month of April, immediately after Bihu.
High level, ma'am.
And but stay, I won't think it is necessary to pass this stay. And you take steps for the respondent. How many respondents are here?
Two, my lord, one government.
One is the state and the two.
State.
Yes, any other submission from your side? I have noted that these days I have submitted that these invoices or all the transactions
ma'am.
were from Kolkata.
Nothing happened in Guwahati, my lord. But their statement says there only zero balance, my lord. 2022 statement and purchase held on my 2017, my lord, after 7 years, my lord.
Mr. N. Borwa.
Yes, my lord.
Heard Mr. N. Borwa, the learned counsel for the petitioner, and also heard Mr. K.K. Das, the learned additional PP, appearing on behalf of state respondent. Okay, this is an application, section so and so, in connection with so and so. To treat providence order against the next further issue notice to the respondent to register AD and as usual process. No formal notice is required to be served on respondent number, state respondent number 1. However, so and so requisite copy DD. Also call for the scan copy of the LCL. The learned at the registry will do the needful in calling the case record. List accordingly. You want any fixed detail name? Your mix is May.
May, my lord, 17 May.
17 May.
It may be 25 April, my lord.
Oh, 25.
Hello,
You take steps.
yes, ma'am.
Oh, 25.
fifty,
Yes.
Sir, may I please your lordship, I had in Zimma in connection with case number NDPS case 196 2024 with NCB number 223. Lordship kindly call for report.
You have next the rejection order, earlier rejection order.
Earlier rejection order is my lord. District and session judge court number 5. And it's at 3 page number 10, lordship.
Page number 10. This is only in connection with only Jimma petition or the bail was also there, only for Jimma.
Only for Zimma.
So quite a lengthy order has been passed. Most probably NCB also filed their objection there. So NCB is sending it. SC NCB. No one is here no? From SC NCB. Okay, can I notice to put it? Training council NCB করবো না লাগে আর নাই হার্ট সো এনসো করি call for the report from the investigating officer as to whether the vehicle bearing registration number AS 11H 6644 bracket or Hyundai Accent is required for a further investigation or not. A report to call for it. List the matter accordingly after 2 weeks. Okay, by listing it after 2 weeks, we're calling for the report. Yes.
70,
This letter will pass out for the time being. Right.
I don't know. There are lots of time being. It may not reach also. Anyway.
80,
May I please, your lordship? Lordship, this appeal petition is for quashing of the case PRC 244 of 25. Lordship, before going into the facts of the case, I would just like to take your lordship to the document page. Annexure lordship 2, that is at page 20, lordship. The operative part is at page 23, lordship. So in this case, lordship, the respondent number 2 is the wife of petitioner number 1 and the daughter-in-law of petitioner number 2. Now they had a matrimonial dispute and thereafter they have entered into an MOU and settled all differences, lordship. And accordingly, we are praying for quashing of the PRC case because subsequently thereto the FIR which was lodged previously was charge sheeted. And the lordship kindly see annexure 3, page 29. If I may, lordship, case record is received on transfer for disposal from the Port of London CGM Kamrup. Peruse the case record. Cognizance of offence 498A of IPC is taken against the accused persons, namely so and so, on perusal of the materials available on record. Both the accused persons are enlarged on notice under section 41A of CRPC. Issue summons to the accused persons fixing 3/6/25 for appearance. And in the and if your lordship, if I may read page 24, there is annexure 2. Sorry, lordship, page 23, withdrawal of cases, clause 3, that both the husband and wife shall withdraw, cooperate in quashing all the cases filed in courts or anywhere else against each other and their family members enumerated herewith. So herein, your lordship, thereafter, further the husband had lodged an FIR dated so and so, which was registered as Sadgaon PS number 208 of 23 against the wife and her family members, and the wife had lodged an FIR dated 21/10/25, which was registered as Sadgaon PS case number so and so against the husband. And therefore, since both the parties have agreed to withdraw allegations against each other and also their family members, it is therefore further agreed upon by the husband and wife that they shall take necessary steps to withdraw the FIRs lodged by them respectively by approaching the concerned officer in charge, investigating officer, and in any scenario, if charge sheet is filed in lieu of the FIRs, then parties to this deed, that is the husband and wife, shall do act as is necessary to quash the said charge sheet, including but not limited to filing of no objection or affidavit before the Honorable Guwahati High Court. So basically, lordship, due to the settlement, now both the parties are going ahead with regard to quashing of this pending cases, lordship. And lordship, with regard to the judgment by of Jian Singh, lordship, it is apparent that when any matter which has a civil connection, including matrimonial disputes of nature, that can be quashed by this honorable court.
If that be the position, why the respondent number 2, you could have made her as a petitioner, joint petition could have been filed.
Lordship, I did suggest that, but they will be filing their respective applications also.
Okay. Heard Mr. M.K. Das,
Lordship.
Telangana Council for the petitioner, and also heard Mr. K.K. Das, Telangana additional BP, appearing on behalf of state respondent number 1. This is an application under section so and so in connection with so and so. Issue notice to the respondent number 2 through registered AD and usual process, and also call for the scanned copy of the LCR. Next further, considering the submission made by the council for both sides, especially considering the fact that parties have arrived at a mutual settlement, the further proceeding, where is the case number is PRC?
PRC
244.
244 of 25.
PRC case number 244 only 2025 under section 498A. IPC pending where?
In the court of RC Fukan, JMFC, Kamrup Metro.
Pending before the learned GMFC, Kamrup M at Guwahati. Be state till next date of listing. List accordingly after 3 weeks.
Lordship, deep your
19.
May it please your lordship. This is quashing with regard to some observation and an imposition of fine on the council by the trial court below. What happened in this case, my lord, will kindly come to the affair that has been lodged in this case in 2008, my lord. 20 September 2008, page 13, my lord. That's the type copy. I'm not on the merit of this case, my lord. And thereafter, my lord, charge sheet comes in, my lord, in the year 2008 itself, that is at page 27. Now here, my lord, charge sheet has been submitted against one Ziten Kolita also. And my lord, thereafter, process has been issued against all the accused persons, my lord, at page 32, my lord. Is the order, my lord, investigation being sufficient, so and so file against so and so charge sheet, Jitan Kolita. Now, this Jitan Kolita appeared, he was on bail, copy has been served, and thereafter trial was proceeded, my lord, after framing of charge. In the meantime, all of a sudden, my lord, he stopped appearing because of reasons. And as such, process was issued with regard to non-bailable warrant, PN and all. And thereafter, my lord, Jitan Kolita approached this honorable court at page 38, my lord. This is the honorable court's order, my lord, 16/12/2024, my lord. Everything has been written down with regard to this. On the consideration of the pair at page 40, my lord, last paragraph, paragraph 6. This honorable court directed to appear him before the lower court below on or before 21/12/2024. Till then, NBW was stayed, my lord. On 21/12, he did appear. And as because the case was split up, my lord, on that particular day, two witnesses were present, 1 and 2. On that day, my lord, 5/2/2025, my lord, the order, my lord, I have challenged, my lord. Page 41. On that 21/12, two witnesses, examination chief were recorded, my lord. On that day, the counsel becomes a new counsel, my lord. He doesn't know what is there in the record. So he made the oral prayer with regard to that, dispense with the cross-examination till the next day. It was allowed. Now, subsequently, on perusal of the evidence and the cross-examined by the other counsel, he said that I will not cross-examine. It has been covered by the cross-examination. On that, this order has been passed. Kindly see, my lord. Accused so and so are present. Accused so and so absent. So and so, when the matter was taken up for further cross-examination of PW1, Kamal Hussain, he is the petitioner before Lordship. He is the counsel. Engaged counsel for accused Jitan Kalita stated that all the relevant questions had already been put to the said witness and he has no further questions to be asked. At this juncture, I have perused the case record and it is to be noted that on last day, 21/12/2000, PW1 was examined and cross-examined by the against counsel for the accused Ramani Kolita Thakuria and regional so and so. On the prayer of Kamal Hussain, further cross-examination of PW1 was reserved and he was called today for his further cross-examination. As apparent, further cross-examination of PW1 has been specifically reserved on the prayer of so and so. I find it pertinent to mention that when a witness is called for cross-examination, the counsel is either expected to proceed with the examination or formally excused of witness in a manner consistent with the interest of justice. To call a witness and refuse to examine without valid reason disturbs the orderly conduct of the accused. The conduct of the said counsel is highly inappropriate and has caused undue wastage of court's time as well as unnecessary inconvenience to the concerned witness. The court strongly rebukes so and so for his unprofessional behavior, and in order to act as a deterrent for any further instance of misconduct, this court hereby impose a cost of rupees on him, the counsel. Can it be, my lord? Without show cause, without anything, comes to a finding, the learned magistrate become the prosecutor, persecutor, and the judge. Cannot be, my lord. So I only pray for stay of this order. Nothing else. Trial will go on, my lord.
Then he immediately
No.
then who received rupees 1,000 in his side it is received.
Is it so, my lord? I have not seen it. What received, Sider?
In the order itself.
1,000. My lord, this order may be state. 1,000 was paid, maybe. Paid. It was paid, my lord. That was not been bought to him. That may be state, my lord.
No, but it has already been paid.
Paid, my lord. Because the council, my lord, he has paid it the amount, my lord. But this observation remains, my lord. It has to be expunged, my lord, from the record. And that's an illegal order, my lord. He'll get the refund.
So you want to stay only the observation part?
Observations part and the fine imposition itself is bad in law, my lord.
No, it's okay. No. Otherwise, the court, the next stage is issue someone to the remaining witness.
Yes, that will continue, my lord.
That will continue.
Continue. Stay of this order with so far imposition and expanse of the, my lord, the observations with regard to, my lord, a council. That's all.
Yes. Heard Mr. A.K. Bhuyan, the learned counsel for the petitioner, and also heard Mr. KK Das till an additional PP appearing on behalf of state respondent. This is an application under section 528 BNSS for quashing the order dated 5/2/2025 passed in GR case number 1285 packet of capital A of 2008 by Civil Judge Junior Division cum JMFC Golpada. So who is Mr. BK Nath? The respondent number 2, who is he?
Kuntu?
BK Nath.
Bikinath is the informant, man. Was the informant in this. He was,
So you
he
have
was
made
record.
party. You have
Not
made
required,
party.
my lord.
Otherwise, it's not required, but
Not-
you have already made, so we'll pass the order of issuance of notice at least.
No,
Subsequently, you may make a prayer.
No, my lord, here I am not aggrieved by.
That's
his
what I'm saying.
deposition
Why you have
evidence.
made party? This 2 is not necessary party.
Not a necessary party, informal party may not issue notice to them. Not,
Yeah,
it
to
is
issue.
actually between the court and the council.
Obviously, that's what I am asking.
Yes.
That's why
But
mostly
as per
BK
High
Nath?
Court rules, my lord, informant is required to be made a party.
Okay, then issue notice to the respondent number 2. Also call for the scan copy of the LCR. Next para, Mr. Bhuya further submitted that in order of 5/2/2025, there was an observation made by the court against the conducted counsel, Mr. Hussain, Mr. Kamal Hussain.
Kamal Hussain.
Kamal Hussain. He was engaged for the defense, no?
Yeah, first day he appeared, my lord, when he made the appearance on 21/12. He was not acquainted with what is going on because evidence was recorded on that day. So he verbally prayed that let the cross-examination be deferred till the next day, and that was allowed. After perusal, the cross-examination is not necessary. So he said not necessary, it is covered. So being hesitated, disorder.
Kamal Hussain, the conducted counsel of for the defense, Mr. Kamal Hussain, and also imposed a fine of rupees 1,000 on him. And accordingly, Mr. Bhuya submitted that the said part of observation and imposing fine against the state council may be stayed or be suspended till next date of listing. Prayer allowed, considering the submission, so and so prayer to allow. The only in respect of the observation made by the learned court below against the conducting counsel for the defense counsel, Mr.
Kamal
Hussain. And also the 1,000 to DRC that is state. Okay, that
Deeply obliged.
list accordingly after 3 weeks.
Deeply.
It will take time. No. Continue with others. It will take time.
20.
May please a lot. Yeah, my lord, the POCSO is there, my lord. 8 of the POCSO Act, my lord.
8 of POCSO is there.
Lordship, my lord. Lordship may issue notice, my lord.
Similar order, issue notice on respondent number 2 to jurisdiction police station, noted to the office of the registry and the public prosecutor. Like no formal notice is required, so and so quotable. This case is at the stage of still investigation stage or actually, how long he has been? Oh, sorry, it is a AB. Okay.
Yes, there will be required.
Yes, case
Yeah,
date
there
will
will
be
be
required. Stating when it can be fixed.
Jury appears, my lord, no. 7, my lord, 7/4.
Before Bihu, because it's a AB, let it be after Bihu only.
21/4.
21.
Lordship. Oblige, my lord.
Item 21.
Let please, your lordship. Yeah, POCSO matter, lordship, that probably notice is required.
POCSO is there. Section 6 POCSO,
Section 8.
8 POCSO. Same order, Section 8 POCSO. Same order, herein can be fixed from Borwa.
But it is
Can it be-
board, my lord.
Whether after vacation or before vacation.
10th or 11th indicate.
11th we are not fixing.
10th.
Why are you insisting? It is a AB, I think.
AB, no, see, the minor children are there in his home, 2 minor children are there.
Those 10th of April. Okay, then 10th of April.
Hold on.
22.
Maybe. My lord, relating to child marriage, my lord, also is there, my lord. Substituted case, my lord.
Oh, it's a charge-sheeted one?
Yes, sir.
What is the stage of the case? Do you know?
My lord.
Summons to
That,
the witnesses or
No, my
accused?
lord, accused, my lord. My lord, petitioner shown to be absconder in the charge sheet, my lord. So there is an apprehension that
Petitioner was charged as an absconder.
absconder,
He is the husband or the father?
husband, my lord.
Okay, issue notice COVID. Respond number 2, same order. So we need here scan copy, I think.
My lord.
Scan copy will be required. Scan copy of the LCR along with the case diary be called for. List accordingly. It will be listed after 2 weeks.
My lord, date may be fixed, my lord.
It's very problematic for us also to fix a date because we don't have
After
date.
Bihu, my lord.
Obviously, after Bihu it will be
23, my lord.
25 for.
On 23, my lord, can it be possible, 23?
25 will be a problem for you.
Yes, my lord.
22.
Obviously.
23.
Yes.
Clear gauge, my lord. PS verification application. Apply page number 17.
17.
Later-
1 7.
Later on, section 6 of POCSO is added. I am coming to that point here. I am first, case number 17, the 16 and 17. There is no allegation of sexual harassment in the FIR. I am coming to that point here. The FIR was filed by one Tito Soma, uncle of the girl. Against their
Her uncle.
her uncle. Against that informant, the mother of the girl against filed one FIR. And he is now in the jail here.
That the
For sex-
informant, so-called
for
informant.
sexual assault on the mother of the guardian. I am coming to the FIR portion here. There is no such allegation. This is a purely case of prohibition of child marriage here. The FIR was addressed to the superintendent of police here. FIR case number 16 here. Superintendent of police of Biswanath district here. The superintendent forwarded that we didn't note in the below party, we didn't note case of child marriage to the needful. We didn't noting here. They are forwarded to the OC of the Jinjia. I am coming to the contents of the FIR. May I read the contents here? With due respect, I beg to state that Miss So-and-so, daughter of So-and-so, age about 16 years, is my now niece who was reading in class 10. The above named culprits forcefully managed her marriage with one person, namely Subhash Sharma, the petitioner hearing, resident of so-and-so, misleading me that so-and-so has been residing in her maternal uncle's house. After knowing the real fact, I have filed this FIR. The name of the culprits here. 1, 2, 3, 4. My name is not there in the FIR. Only allegation that they have forced the girl marriage with me here. I am coming to the real facts here. The petitioner and the girl introduced themselves in through Facebook here. The girl were informed the petitioner that she is a she is a girl of class 12. And he has already appeared class 12 exam in the 2024 year. Accordingly, after her mother has already died here. She lived with her mother in the uncle's house. The informant here in the uncle's house. Knowing the relationship, the uncle forced the girl, forced the petitioner to take the girl to his home here. And accordingly, in April 2024, the petitioner took the girl to his home and arranged to socially marriage here. Later on, he came to know from the birth certificate that she is not 18 years. Accordingly, he sent back the girl to maternal house and he assured that he will marry her. And accordingly, in the month of May, he went to Bangalore and joined one security company. And I have mentioned detail that in which company he has. Later on, against the informant, forced it on telephonic conversation the boy that he had to take back the girl, otherwise he would file a case under child marriage. And accordingly, I have annexed the air ticket order. On an 25-year, the girl alone went to Bangalore by flight order. And annexed the air ticket order of case number 25. On 4th August 24, she alone went to Bangalore, meet the petitioner order. And thereafter, the petitioner arranged to give her in a girl's hostel for few days, and thereafter they lived together as a husband and wife. This is admitted person. And in the month of December, this FIR was filed, and police informed the victim, mother of the victim girl, that her statement is required. Accordingly, she alone returned to Guwahati on 10th January 2005. Flight order. I have annexed the flight ticket order. And her statement was recorded and she was sent to medical examination. On medical examination, it come to know that she is in the early stage of her pregnancy, 1 month. Thereafter, the IO made a pair before the concerning court to add section 6. And accordingly, flight order added 22/1/2025. Section 6 is added in this case, case number 29.
Now, okay, I can understand that with the misconception that she is a major girl, he proposed her for marriage and then they went and stayed together.
Even in her Aadhaar card, her age is mentioned as 19 years. That is why she can alone go in the flight order. She booked her ticket on
But now, see, now the question is that when the case was registered, FIR was registered, then it has come that she was a minor at the time of when she was there along with the petitioner, because formally, most probably, marriage is not yet solemnized between them,
But they
living as a husband and wife. So that is the main crux of the case. So that's why section 6 is there. You cannot have a sexual intercourse with a minor girl. In spite of her consent is not required, whatever, but the question is that you were staying as a husband and wife. That means we had a physical relationship with her. That is the case, and that's why 6 is added.
Yes, I have no objection, but if he is found guilty in the trial, he will send to the jail. But at this stage, his attendance is very much required for the welfare of the guardian.
Okay, but the question is that unless 6 is there, so we have to issue notice. We don't have any alternative, in fact.
I have made party the mother of the informant as the mother of the guard, as the informant is in the jail. So the mother and guard has information about filing of the bail application. My humble prayer is just making within a week, if possible, my humble.
No, we have to issue notice to her.
Yes.
Ah.
Already they have knowledge about filing of the bail application. Formal notice may be issued and they will accordingly appear. They will accordingly appear.
Yes, and yet,
In this case, my lord, informant is the Tirtho Sharma also. But he has not made the Tirtho Sharma as a party, my lord.
That is not
He has
required.
made the, my lord, mother of the victim girl party, my lord. Secondly, my lord, there are allegations, my lord, against this person, my lord, in the FIR, my lord. There is specific allegation against this person in the FIR. And
who's person? Who's
Petitioner, my lord, Subhash Sharma, my lord.
Subhash Sharma.
Page number 17, my lord.
Yes. Now he is the, yes.
Culprit forcefully managed or married with one person, namely Subhash Sharma, my lord.
Yes, yes.
That is the allegation, forcefully married with Subhash Sharma, my lord. That is, my lord, whether it was his knowledge or not, that will leave it from the case diary, my lord. Now he has
Everything will leave it from the case diary. Now they have made party the mother.
Mother, my lord.
That can be.
Mother can be, I think. Guardian can, one of the guardian can be.
That can be. Anyone of relative of the guardian.
Informant,
Mother
victim,
is-
or the guardian can be made party.
Uncle is, mother is close to the girl, better than the uncle.
Anyway,
And
my
against
lord,
the uncle already
may issue
FIR
notice, my lord. Issue notice and may call for a case diary.
So my humble prayer is considering the situation herein, for that may be given so that
No, it has to come from where? Biswanath.
business side. But informant, victim girl and mother, respondent to have already knowledge that bail petition is filed before the honorable court. As
They may appear.
all
as per-
are living together here. The petitioner, mother and girl all are living together here. That is the real fact, I would say.
We have CD bill received with before Bihu.
My lord, we can fix this on my lord.
Second to
Eight, my lord, eight of it.
8 is many matters. It's possible. 8 will not be possible. At best 9. 9. Issue notice করে দিব। I'll take it. It will not be different. Issue notice করে issue notice to the respondent number 2 to judicial police station or to the office of the registry and the public prosecutor. And also call for the CD. Petitioner will take steps এবার লিখিব। Based on 9th. 9th of April.
Obliged.
নাম তো লই লব না তো লই লব এটা Fenda Mandal, she is the informant.
Yes, Your Honor. She is the informant and the mother of the victim girl.
Victim means how many victims? Only one?
Only one victim.
Again, same order হবে issue notice করে দিব হাট করে দিব Mr. RJ Burga and Mr. T. Dewi for the petition, same order. Fixing it at
Any date after the.
after Bihu
23.
23.
I'm deep. Your Honor.
25.
Net please, Your Honor. I think it is the clearest bail application, page 14 is the FIR, madam. Kindly peruse it, madam.
Page 14.
Page 14. Madam, I am a driver. My vehicle was hired from Hojai to join these two accused persons in a religious congregation that held at Dhekiajuli in the month of February, madam. Madam, so I came, madam, I have halted the vehicle outside. So they have entered to the religious congregation. This is their contents, madam. It is respectfully submitted that on 15 to 25 at about 11 a.m. while I was busy in the religious congregation, the Ittima at Baptola under Dhekajuli police station, my Vivo mobile was pickpocketed from my pocket. They were caught beside my mobile. The police have recovered 15 mobiles along with mine from their position. This is the against the two accused persons whose name in the affair. But I was the driver, I was outside. When police came and police took them to the police station and I said, how you have come? They said, we came in vehicle. They did not get me. They have taken the police also taken the vehicle to the police station. Now, my lord, I have in no way connected. I am just owner and driver of the vehicle. So, my lord, I want to go to the police station to bring the vehicle now because I am afraid now because I will be arrested. That's why, my lord, I have come before you, my lord, under pre-arrest permission. Kindly call this CD, my lord, I may be protected, my lord.
Let him appear, madam.
I will appear.
Heard Mr. S.C. Biswas, the learned counsel for the petition. And also heard Mr. R.J. Borga, the learned additional PP, appearing on behalf of state respondent. This is and so, against so and so. So it is submitted by Mr. Biswas that the that he is no way connected in the alleged offense. He was the driver of the vehicle and at the time of the said incident, he was outside the vehicle. However, he has the apprehension of being arrested. No. Outside the course of your vehicle has already been
police
seized.
station now. I cannot go
But
out of fear.
The vehicle has already been seized by police, and hence he is not even in a position to presume for the said vehicle. There is an apprehension of being arrested in connection with this case. However, he is ready and willing to cooperate the IO in further investigation and so forth. Okay, you'll be under interim protection.
Kindly.
Appear before the IO.
Within 7 days or 10 days.
Yes, 7 days, within 7 days.
34, madam.
30.
30.
Develop it.
Oh.
26.
May I please, your lordship? Lordship, 482 bail application, lordship, FIR will find in page number 19. So, particular. May I read, my lord?
Yes.
সন্মান সহকাৰে জনাও যে যোৱা ইংৰাজী 7/2/2025 তাৰিখে সন্ধ্যা প্ৰায় 7মান বজাত তিনিজন অচিনাকি মানুহে আহি মোৰ ঘৰত আৰু আমাৰ ঘৰৰ কাষৰ নিবাসী শ্ৰীমতী মান্দিক থামথামৰ ঘৰত কোনো সোধপোছ নকৰি অনাধিকাৰ প্ৰৱেশ কৰি ঘৰৰ তালাচী চলায়। ঘৰৰ বয় বস্তু সকলো তছনছ কৰি নিচাযুক্ত দ্ৰব্যৰ বিচাৰি ধান কৰে আৰু আমি নিচাযুক্ত দ্ৰব্য ব্যৱহাৰ কৰোঁ বুলি কৈ অশান্তি কৰে। আৰু মোৰ বেগত থকা মোৰ সাঁচতীয়া পইচা মোৰ 20,000 টকা লৈ যায় আৰু আমাৰ বেগত খেলিমেলি কৰে আৰু 1 লাখ টকা দাবী দি শ্ৰীমতী মান্দিক থামথাম আৰু মোক লগত লৈ জোৰবস্তি তিনিআলি টানি নি চেগুনবাৰী তিনিআলিত থকা ICICI বেংকৰ ATM-ত নি মোক 40,000 টকা উঠাই লয় আৰু অহা কালিলৈ পুনৰ 60,000 টকা দিবৰ বাবে দাবী ধমকি দিয়ে। যদি নিদিয়ে পুলিচ লগাই জেললৈ ভৰাম বুলি ভয় দেখুৱাই অহা কালিলৈ পইচা গোটাই থবৰ বাবে ফোন নাম্বাৰ নম্বৰ দি থৈ যায়। পইচা যোগাৰ হলে উক্ত ফোন নাম্বাৰ ফোন কৰিব কয়। সোধপোছ ক্ৰমে লোককেইজন নাম চয়ঞ্চ বুলি জানিব পৰা যায়। গতিকে দয়ালু মহোদয় লবিতৰ here 3 named persons names are mentioned, my lord. I am for the first person. Absolutely false allegation, my lord. I am a businessman by profession and I have a business of supplying goods in Assam, various districts of Assam as well as in Arunachal Pradesh. For a moment, lordship, may kindly peruse annexure number 2. It is a document executed by the husband of the informant in the month of August 2024.
Which one? Which annexure?
Page number 21, the next annexure, my lord. Annexure number 2, page number 21. This is the money received, my lord. This is executed by issued by the husband of the informant. It is a fact that I gave him 1 lakh rupees to arrange a space, 2,000 square feet of space to keep my goods in Arunachal Pradesh. He is a resident of Arunachal Pradesh. He is presently staying in Margherita. So he assured me to give that space. And as I was in urgency, so I gave him 1 lakh rupees after receipt of this money receipt. What happened? Thereafter, I came to know on every occasion he postponed the issue by showing some lame excuses that he is arranging some space. But finally, he didn't give me any space. So I went to his, not only on 7th, my lord, admittedly, I went on 5th of February also. On that, the husband was present. I told him that to return my money. Then they asked me to come on after 2 days. On 7th, I went there, and it is a fact that in FIR, they correctly mentioned that yes, I went to the ATM because on that day, the informant told me that she don't have cash with her. So she requested one of her neighbor to throw her ATM, they will withdraw the money. I went there. It is not mentioned that I was entered into ATM. It is admitted. I entered into ATM because they said that I don't know how to operate the ATM. I entered into the ATM and withdrawn at 40,000 rupees. And they said that on next day, they will return me the remaining amount. And I also tell them that if you will not return the money, I have the document, I will inform the police. It is mentioned in the FIR that I threatened them. They stated that, but I informed them that I'll inform the police because your husband already for a couple of months is not returning my money. And lordship may kindly see the number which is mentioned is a correct number. It's my number. It's also mentioned in my affidavit also. As per the new rule of the registry, I mentioned about the phone number. This is the correct number. If I went to the residence of the informant with the intention to extort some money, why I went to the ATM machine, lordship? Because everyone knows that there are CCTV camera installed in the ATM machine. And why I mentioned my correct number, gave my correct number, my lord. It's absolutely false. To abstain themselves from giving me the remaining 60,000 rupees, they lost this false allegation against me, FIR. Now I am in trouble, my lord. I paid the money. Now I am in trouble, my lord. 40,000 I received. I admit it. But the remaining 60,000 I have not that we have not received, and they filed this false allegation, my lord. My lord, call for the case diary, my lord, and till that I may be protected, my lord. I'm an innocent businessman, lordship. I need some space in Arunachal Pradesh. I gave the money to the husband. Now I am in trouble.
My lord, question is that, my lord, if there is some business transaction also, my lord, he cannot force anybody, my lord, to go to the ATM and, my lord, to withdraw money, my lord. Because there are specific allegations that, my lord, the informant was taken to the ATM, my lord, where from, my lord, 40,000 rupees was withdrawn, my lord. It is a forceful, my lord.
There is no force. Please.
Secondly, my lord, he has been named in the FIR, my lord. Assuming there are some business transactions, my lord. Even though, my lord, he cannot force anybody, my lord. to take to the ATM machine, my lord, ATM counter, my lord, and my lord, forced to withdraw some money. So let the case diary come, my lord. After that, my lord, if required, Dorsey may, my lord, protect him, my lord.
May I submit, madam? In the earlier part of in the initial part of the FIR, they said that there is no Osinaki Manu. And subsequently, they named they already know my name. Husband very well know me for last couple of months. So there is no force. I went on 5th. They requested me to come on 7th. And when I came to 7, husband was not present. That was maybe a pre-plan. And they said that we don't have money. I have to take money from my neighbor. That neighbor also went along with me to the ATM, my lord. I went inside the ATM. There is no force. If there is any force, that may be I have to keep any of their family members with my other friends so that they go along with me, because there are so many people in that particular secondary Teniali. They can make hue and cry if there is any force at all. Nothing mentioned in this FIR, my lord. Willingly they gave me 40,000 rupees. That is my entitlement. And what my prayer is that, my lord, call for the case diary till that I may be protected. My money, lordship, I have gave to the husband. Now I am in trouble, my lord. There is no force at all. They could have made hue and cry in that ATM machine. There are so many policemen, and at evening 7 p.m., my lord. It's not like that in the early morning or in the midnight. Always so many gatherings, people gathering in that particular area in Tiniali.
Okay. Asking number 26 now. Heard Mr.
PP Botak.
the Land Council for the petition. And also heard Mr. R.J. Borba, the Land additional PP appearing on behalf of so-and-so. And this is an application under section so-and-so in connection with so-and-so seeking so-and-so. Next prayer, Mr. Botako, the Land Council for the petition submitted in this regard that the FIR has been lodged with some false and concocted allegations full stop. It is a fact that there was a business transaction with the husband of the informant, and as he was in need of some space in Arunachal Pradesh to keep his what kind of business? Keep his
To supply goods, to store some
to
goods in
store
the
some
particular
supply
area.
goods in Arunachal Pradesh, and on the assurance given by her husband, he also gave rupees 1 lakh to the husband of the informant. But subsequently, he did not give me any space, and for which when he demanded money, when he returned back the money, when he asked to return back the money, the husband of the informant, asked him to come to his house on 5th of February 2025, and accordingly, he visited to his house on 5/2/2025, and subsequently on. And it is also an admitted fact that on 7/2/2025, he again visited when through ATM, through the ATM card of the informant, she took out rupees 40,000 and paid to him. Whatever money he received is his entitlement, and he is still yet to get another remaining rupees 60,000 from the husband of the informant. However, the accused petitioner is ready and willing to cooperate the ILO in further investigation of this case if he is granted with the privilege of free arrest bail. Next para, Mr. Borba, the Land Additional PP, raised objection and submitted that even if he had any business transaction, he cannot force anyone to go to ATM and to take out money and take out money where as alleged in the FIR. Full stop. Accordingly, Mr. Borba insisted to call for the case diary to know the actual fact of the case. Full stop. Next para, considering the entire facts and circumstances of this case and hearing the submission made by the Land Council for both sides, the CDB called for Koidiva until so and so. Okay, will be under interim protection. CD will be called for appear before the IO within 7 days. Yes, Borba, when it can be?
29/4 months.
29/4.
Acknowledge, Your Worship.
27.
May I please, Your Lordship. PS bail application, Lordship.
Yes.
Page number 17, Lordship. Bharatpur FIR, Your Lordship.
17.
17. May I read, Lordship? সন্মানপূৰ্বক বিনীত নিবেদন এই যে আজি 14/3/2025 তাৰিখে দিনৰ প্ৰায় 4:30 মান বজাত মই ৰেল ষ্টেচনৰ চৰকাৰী কৰ্ম কৰিবলৈ আহি থকা অৱস্থাত উক্ত অপপক্ষগণে মোক বিনা কাৰণত নকাৰী ৰেল গেটৰ সন্মুখত আগুচি ধৰি পিছফালৰ পৰা চুলিত ধৰি মাটিত বগৰাই পেলাই আৰু হাতেৰে চৰ ঘুচা মাৰি শৰীৰৰ বিভিন্ন ঠাইত জখম কৰে ও প্ৰাণনাশৰ ভাবুকি দিয়ে উক্ত পক্ষগণে মোৰ নিজ জাতত ধৰি গালিগালাজ পাৰে Upon receipt of the state Ezahar police registered place under section Lordship 115 of clause 2, 299, 351 clause 2, 3 clause 5 being under Lordship. Actual fact of this case, Lordship. Actual fact of this case, Lordship. On 14/3/2025, some young boys were celebrating Holi, Lordship. In the meantime, informant on the way to he is performing his duty. At the point of time, one young boy throw holy color to the informant, Lordship. He never know to he belong to Muslim community, Lordship. Thereafter, he informant slapped the boy and created a situation, Lordship. Thereafter, petitioner somehow managed both the parties and controlled the situation, Lordship. Upon Uttaran came to know that the informant lost the FIR against the petitioner, Lordship. This is the case, Lordship. All the sections are available, Lordship. Section Lordship 399, 299 is the non-bailable, Lordship. 3 years imprisonment, Lordship. This is fine. Yes, Lordship. He is not
Elimination of my lord physical assault is also there, my lord. That case diary and my lord injury report may be performed.
also unlimited intent may allow.
You are Mr.
This would be allowed.
D. Suti. Heard Mr. D. Suti, the land council for the petition. And also heard Mr. R.J. Burga, the land edition people, so and so. This is an application under section so and so in connection with so and so. Considering the next file, considering the submission made by landed council for the petitioner and other aspects of the case, let the CDB call for along with the medical report. Until receipt of the medical report, I find it fit case to extend the privilege of pre-arrest bail, interim pre-arrest bail to the present accused petitioner till the receipt of the case diary. You will be under interim protection. Within 7 days, you appear before the IO and cooperate in the investigation. We are also calling for the case diary.
34.
30. 30. 34.
28.
May I please? What's it? Is it an anticipatory bail application, my lord?
Timing of what I was saying. The question is that NCB has now I they have come. They were ready. Yes.
My lord, anticipatory bail application, FIR is at page 17. Is an FIR by my lord Bank, Central Bank of India against its employees, my lord. May I read, my lord? The relevant para will be, my lord, 2, paragraph 2. It has come to my knowledge that by so and so being sent by the central office, there has been misappropriation of funds from the period of so and so. And also on various dates, the cumulative financial loss has been caused to the esteemed bank is to the tune of 51 lakh so and so. Sir, the alleged incident that occurred during the period of so and so to so and so, these persons, namely number one is the petitioner, my lord. He was then the branch manager, my lord. My lord, may kindly note the branch name was Borbari branch, my lord. Borbari branch in Guwahati, my lord. There is a discrepancy in the amount present in the ATM machine, my lord. It is a cumulative, my lord, amount. The amount has occurred on different dates. Differences occurred on different dates. My lord, the number 4, para number 4, that, sir, as the matter is still under investigation and also to safeguard the well-being of the staff, members, and thus the departmental inquiry is under process. Simultaneously, my lord, departmental inquiry is also, my lord, under progress. Now, my lord, the main fact, what has happened actually? My lord, may kindly come to page 21. Even before petitioner was in that branch, and after petitioner was transferred from that branch, my lord, this differences remain occurring, my lord, because the ATM machine itself was malfunctioning, and the central office, my lord, at Calcutta gets the information through a machinery process, my lord. It is called switch, ATM switch. It is a machinery process, my lord. My lord, kindly see page 21. It is a letter by the regional head of Guwahati regional branch, my lord. The column 1 will be important, my lord. As per the letter received from central office dated so and so, we were advised to submit a report of the reason for differences around 51 lakhs in cash deposit account of ATM so and so installed at Borbari branch so and so. Now the next paragraph will be important, my lord. On so and so, our regional officials have extracted machine counter and switch steps, and it was found that machine counter was showing so and so, switch so and so as remaining balance respectively. However, the physical cash in the machine was so and so. As per trial run in presence of the RO officials, the Borbari branch manager, cash was replenished and ATM with so and so, and again after so and so. Difference in the machine and switch counter indicates error in functioning, my lord. The system was error, my lord. This has been also noticed, my lord. My lordship may find at page 25. This has also been noticed by the regional office and informed to the head office, central office. Page 25 is the letter, my lord. This is also regarding Borbari branch. Lordship will find the name of the branch at first paragraph, line number 4. It is regarding Borbari branch. Now the number 1. ATM machine was under malfunctioning as loading cycle from so and so, so and so. So these are all the events, my lord, all the dates, my lord, when the ATM machine was malfunctioning, my lord. Malfunctioning was sometimes it is dispensing much amount than what has been typed, my lord, and sometimes report has been, my lord, falsely given. All these things are happening. That is why, my lord, lordship may kindly find at page 24 again. 24. Regional officer, my lord, regional head has noted, my lord, of other precautionary action taken to protect the interest of the bank. We have taken custody of CCTV footage of the branch and checked it from 14 July to 16 July, but we could not find any suspicious activity by any staff official. We have checked number 2, CCTV footage of ATM surveillance were also following up with the vendor NSA on regular basis. NSA is the a company which do this reconciliation process through switch machine. So this switch machine was malfunctioning. Therefore, my lord, this NSA gets wrong information and discrepancy arises, my lord. We have checked the statement of all bank account of concerned staff members, but no abnormalities observed, my lord. Regarding us, my lord, inquiry has been done thoroughly by the bank officials. It is a very technical matter, my lord. I'm not denying that there is a possibility of any investigation, my lord. That is true. But as a bank manager, my lord, I cannot flee from any investigating authority. Therefore, my lord, at this stage, my protection may be considered. And as for my information, my lord, this FIR has been lodged because it has been lodged on 4th March. And till date, I have not been called for by the police. As per my information, my lord, this FIR has been lodged only for insurance purpose. Malad, the amount segregated for a particular ATM that remains insured, man. And for this insurance claim purpose, this FIR has been lost, as per my information, madam. Considering these aspects, my lord, and moreover, my lord, my wife is, my lord, 8 months pregnant. That's a we look into, my lord. That is my.
Garnet Finance fairly submitted, my lord, police has not called him till now, my lord. So I, my humble submission, there is no apprehension, my lord. FIR may be lost, my lord, there are allegations against him also, my lord, being the, my lord, branch manager, my lord. And the period has also been specifically mentioned, my lord. Well, let the case that call from, my lord, because since my lord, police has not searching him also, or no notice has been issued to him, my lord. So there is, my humble submission, there is no apprehension.
That cannot be the case, my lord, because once it has been registered under, my lord, non-valuable sections, my lord, and there's always there is my apprehension, my lord. That is why I am before your
But
lordship.
there is, my lord, specific, my lord, the aberment is the, my lord, bail application, my lord. The police is searching, mayor, my lord, losing of the FIR, my lord, will not, my lord, say, police may not arrest him, my lord. The investigation, my lord, police has found, my lord, there is custody interrogation may not be required, my lord. The police may not arrest him also, my lord.
I will appear before the IO, my lord, as your lordship directs.
Mr. Fukon,
Yes.
heard Mr. M. Fukon, the learned counsel for the petitioner, and also heard Mr. R.J. Purva, the learned additional PP, appearing on behalf of said respondent. This is an application under section so and so in connection with so and so. Next paragraph. Mr. Fukon submitted in this regard that the present accused petitioner is not involved in the alleged offense. It is a fact that during the relevant period of time, he was a branch manager of Borbury branch. But during that period, there were some defects in the machinery, error in the machinery functioning of the ATM machineries. And hence there was some differences of money which was deposited or reported before the concerned authority. He further submitted that in that regard, there were some correspondence were also made to the branch, to the section manager regarding the error in functioning the ATM machineries, and the department also taking steps in that regard. However, the present accused petitioner is not called by the police till date, not he was searched for, nor he received any notice from the police. But he, being the branch manager at the relevant time, he has the apprehension of being arrested in connection with this case, and hence prayed for some interim protection. However, he is ready and willing to cooperate the IO in further investigation of this case if he is granted with the privilege of interim pre-arrest bail. Next one, Mr. Burwa, the learned edition PP submitted in this regard that the counsel for the petitioner fairly submitted that he is not searching by police till date, nor he received any notice to that regard, and thus there cannot be any apprehension of arrest and arrest in connection with this case. Accordingly, full stop. Accordingly, he insisted to call for the case diary to know the actual fact of the same. Next para, considering the entire submission made by the learned counsel for both sides, FIR and annexures filed along with the petitions and other aspects of the case, I find it a fit case to extend the privilege of interim pre-arrest bail to the present accused petitioner till the receipt of the case diary. Okay, will be under interim condition.
Myself. And I will appear.
Yes, appear before the IO within 7 days from the date. There will be some other conditions about bail.
Yes.
25. Based on 25.
Much of.
Thank you. 50. And what I'm going to do.
Only 2 and 3.
Mr. Kyle, or you are going to argue? You're going to.
My lord, I've given two sheets of paper. This is two and this is the case, my lord. This is for item 2 and the other is item 3. This is my case, my lord. 3 years, 2 months and 26 days. Out of 11 witnesses, only 3 witnesses have been examined so far. PW4 is incomplete. Ground for bail, my lord, prolonged incarceration. And my lord, last witness was examined on 11/9/2024, though incomplete. And these are the dates. And 3 of the co-accused, my lord, had already been enlarged on bail. Page 64 is the bail order. This is for item number 2. That's my case, my lord. Basically, this is my case. And for item number 3, same case. There were 6 persons were apprehended. 2 were in the truck and 4 were apprehended from on the basis of 67 statement. Out of those 4 who were apprehended on the basis of 67 statement, 3 had already been enlarged on bail, and the 4th one is item number 3. Therefore, in item number 3, that synopsis which I have prepared, your lordship will see grounds for bail. There is an additional ground that apart from prolonged incarceration, that nothing has been recovered from his possession, arrested on the basis of statement accorded under 67 CRS. And both of them were 3 years, 2 months, 26 days, and item number 3, 1 day less, 25 days, because he was arrested on the next day. And as far as my lord, and my lord, I will not burden your lordship with all those citations already many times, my lord. I'll just indicate 2 judgments, and I'm relying on these judgments. And I've given the para numbers also, my lord. These are very recent orders of the Honorable Court, my lord. My lord will see, I have even flag marked those. From para, such and such, I am relying. Because all the case laws have been discussed from those paragraphs. That's my case.
Yes.
Please, your lordship. In this case, he was arrested on 27/12/2021. 221.750 kg of ganja was recovered from his conscious possession. And the charge sheet was filed on 22/6/2022. Out of 11 court witnesses have been examined, lordship. The 4th one is partly examined. Now, regarding the role of the present petitioner, lordship, may come to page 73 of my objection.
Item number
2.
73 of your objection.
Yes.
I said the objection. Just a second, we are. Objection, I said the objection.
This is regard to item number 2, lordship.
Just I was checking.
In 3 written objection, I think it's not that motion.
We don't have a objection. For us, it was filed on 18/3, I think.
My lord, what I can do is that they have served me also a copy. For the purpose of hearing, your lordship can take these 2 copies. And in the meantime, I'll give a requisition, it may be called, my lord. For the purpose of hearing, these 2 copies will do, because this is the same copy which they have served. This is for item 2 and item 3. Just to save the time of the court, my lord. In the meantime, we can give a requisition and get it done.
So in item 2, your objection is in page
73.
Item 2 to control.
The name is Shambhu Dev Burman.
Shambhu is item 2.
The 7th page of the objection.
73.
7th page.
73 running page.
Running page.
Running page is 73.
73, lordship.
Yes.
Regarding the role of Shambhu Dev Burma, lordship, para 15. May I read? That the seized ganja, which is a commercial quantity, seized from the truck bearing number so and so, and which was in the conscious possession of Shambhu Dev Burma and Rakesh Kumar. Lordship, my learned friend has submitted that this was not seized from the conscious possession. It was
For item 3, I have submitted that.
Apologies, lordship. Para 18, lordship, that as the voluntary statement given by Pavitra Dev Burma, he along with Ashish Dev Burma, Mithun Dev Burma, Shambhu Dev Burma, and so are the supplier of this seized 221.75 kgs of ganja. As voluntary statement given by Ashish Dev Burma, that Shambhu Dev Burma is involved in the trafficking of ganja, and he is also one of the supplier of the seized ganja. Para 19, Lordship. As voluntary statement given by Mithun Debbarma that Shambhu Debbarma is a partner of Pavitra Debbarma is illegal trafficking of ganja, and Shambhu Debbarma along with others are the suppliers of the sage ganja. Then your Lordship may come to page 74, para 22. That on analyzing the CDR of the mobile number so and so of Shambhu Debbarma, it was found that the Shambhu Debbarma was in contact frequently with the supplier Mithun Debbarma, Ashit Debbarma and Kartik Debbarma during the period of seizure. So Lordship, he was involved in this offense. The CDR is also there, Lordship, and the statements are also there. The contraband has been seized from his conscious position. And regarding the trial, Lordship, I will place the judgment of Kalyan Chandra Sarkar, Lordship, regarding Article 21. Long incarceration cannot be a ground to grant bail. And Lordship, also in the
You are
case,
relying on Kalyan Chandra?
yes, Lordship. I will supply a copy of it.
Pappu Yadav. There is Pappu Yadav, no?
And also, Lordship, one of the recent judgment of Apex Court in Kasif judgment, the role of the purpose and the role of the NDPS Act has been stated, Lordship.
Here, Kalyan Chandra, you are relying on which para?
Para 17, Lordship.
17?
17. May I read, Lordship? Para 17. It is quite law that personal liberty cannot be taken away except in accordance with the procedure established by law. Personal liberty is a constitutional guarantee. However, Article 21, which guarantees the above right, also contemplates the deprivation of the personal liberty by procedure established by law. Under the criminal laws of this country, a person accused of offences which are non-bailable is liable to be detained in custody during the period of trial unless he is enlarged on bail in accordance with law. Such detention cannot be questioned as being violative of Article 21, since the same is authorized by law. But even persons accused of non-bailable offences are entitled for bail if the court concerned comes to the conclusion that the prosecution has failed to establish a prima facie case against him, and or if the court is satisfied for reasons to be recorded that in spite of the existence of prima facie case, there is a need to release such person on bail, where fact situations regarding require it to do so. In that process, a person whose application for enlargement on bail is once rejected is not precluded from filing a subsequent application for grant of bail. This is one para I am relying on it. Regarding the Kasif judgment, para 39. Roman 1. May I read, Lordship? The provisions of NDPS Act are required to be interpreted keeping in mind the scheme, object and purpose of the Act, as also the impact on the society as a whole. It has to be interpreted literally and not liberally, which may ultimately frustrate the object, purpose and preamble of the Act. Roman 2, Lordship. While considering the application for bail, the court must bear in mind the provisions of Section 37 of the NDPS Act, which are mandatory in nature. Recordings of findings as mandated in Section 37 is sine qua non is known for granting bail to the accused involved in the offences under the NDPS Act. This is my humble submission.
Two lines regarding the two judgments which he has submitted. My lord, this Sarkar case that is commonly known as Pappu Yadav case. My lord, in that case is an authority on the parameters of subsequent bail applications. That is because in that Pappu Yadav case, my lord, if I remember correctly, my lord, 6 or 7 times his bail applications were rejected by Supreme Court as well as High Court. So he was filing subsequent multiple bail applications was filing. That is in that context, this Pappu Yadav will come into play. And my lord, much water has flown after Pappu Yadav. Pappu Yadav is of which year? This Kalyan, I'm not having a copy of that. Huh? 2004, 5, nah? That is more than 10 or 15 years back, this Pappu Yadav, that Bihar famous case, my lord, where this political assassination. So that is regarding Pappu Yadav, and neither Pappu Yadav is also not on NDPS Act. Be that as it may, my lord, as far as this Kasif is concerned, my lord, last time also Kasif was dealt by this court as well as the coordinate benches of this court in all the recent judgment, including those judgments which I have given. Because in Kasif, my lord, the period of detention was 1 year or 2 or 3 months. That was the period of detention. This is one. And secondly, my lord, an observation in a bail application is hardly my lord, is a precedent, my lord, because these are observations in a bail application time and again, etc. My lord, I'll not bother your lordship with any more authorities. Your lordship has already perused by now, my lord, because there are multiple orders from this court as well as coordinate benches, where it is said that an inordinate delay of 1 year, in some cases 1 year, 3 months. My lord, yesterday I came across a case, yesterday, my lord, where a man he was involved in 2 cases. Our Kamrup Metro here in Guwahati one and the other in West Bengal. In both the cases, 1 year, 3 months, the Supreme Court has granted him bail. So, my lord, I have given, my lord, if he says Kasif, I have more recent than Kasif, but I just don't want to bother your lordship with all this, but I'll just give for the sake of record 1 year, 3 months, 1 year, 4 months, 1 year, 6 months. These are post Kasif. That is my humble submission. And co-accused have been enlarged on bail.
That's in item number 3.
Item 3.
Item number 3.
There is a synopsis for 3 also, madam.
Yes.
3 is a better case because in 3, nothing was recovered from his possession. In item 2, this man was the driver. With item 3, he was not there. That synopsis you'll not able.
Yes, I have.
I'm deeply afraid.
That's my bail objection.
Yes, your bill.
Page 82.
Page 82.
Yes, sir. Para 15. Lordship is there. That Alinder De Parma, the present petitioner, was the driver of the Bolero bearing registration number so and so, which was used for escorting the truck bearing registration number so and so, loaded with seized 221.75 kgs of ganja. Para 16, Lordship. That Alinder De Parma confessed in his voluntary statement that he was a part of the conspiracy of the trafficking of the seized ganja, and Pavitra De Parma offered him to go Bihar, driving a Bolero bearing registration number so and so, for security of truck loaded with seized ganja, and he was also paid rupees 10,000 for this, and he agreed for it. Next para 17, that Alinder De Parma confessed in his statement that Pavitra De Parma, Ashish De Parma, Gudu Rao, so and so, and he himself were in Bolero bearing registration number so and so, for the safety and security of the ganja loaded in the truck and going ahead of the truck bearing so and so. As voluntary statement given by Alinder De Parma on 27/12/2021, he along with Ashish De Parma, Pavitra De Parma, Alinder De Parma on 27/12/2021 reached Guwahati at about 7:30 hours, booked the room number so and so, and was waiting for the truck to be loaded with ganja. This is the role of the lordship, the current petitioner, lordship, and the trial is at the same stage. Both are arising out of the same LCB crime number, and I'm also relying on the same judgment which I have relied on the first case.
I'm deeply obliged.
Lordship, with regard to item number 32, LCR has
32 call bhi nahi kiya. 32 has not been called, madam.
perhaps the LCR has not been received, Lordship. So this matter may be taken on some other day, Lordship.
32.
32. Bail
Let the
application
item be
number
called for.
543.
Let the item be called for.
Kim. আপনি ডিডি বলুন on behalf of. Yes. Is what you're saying 32.
32.
Ah.
Lord, LCR has not been received in this case. So lordship can fix it on some other day also.
It's a bail hearing. It may be fixed. Obviously, it will come after Bihu only, not
My lord, after Bihu, my lord, because here also very more than 3.5 years perhaps, my lord, because my lord, I have also inquired, my lord, that whether the requisition has gone, my lord. Probably they are sending it by today because I am also the trial court advocate, my lord. So I've
No,
also.
we are preoccupied with prior Bihu. There are lots of that's why I'm fixing it on after Bihu, immediately after Bihu.
Maybe
We do not have any dates to be filled up. In fact, some urgent matters I'm filling up, 7, 8, 9, all are fixed matters. So after Bihu, immediately after Bihu, we'll try to. Immediately after Bihu, right? 23. 23, what do you do now? 23, 4.
Well, can it be 23 after? Well, can we try on 11th?
23, 4.
Much obliged, lordship.
Issue reminder for you. LCR has not been received. Raised is to take steps. Issue reminder to following the case, scan copy of the LCR. Raised will do the needful. List accordingly 23, 4. Okay,
In the meantime, if they want to file any objection, written argument, all those they can file. Otherwise, on 23, they will come up with an adjournment.
In the meantime, if the responsive NCB is in the meantime, the NCB can file their written objection if any.
Much obliged.
Three more time. After 2, 3, what was the other one? 4. Fourth part of them.
Timing.
It may be disposed of. These
Yes.
2 entries.
Timing 4.
Met your lordship. Where in which case, lordship, the petitioner is in custody since 12/11/2024.
12, 11,
Yes,
24.
24. Your lordship may kindly see the FIR. I'm taking your lordship to relevant portion at page 17, lordship. I'm not on contents of the FIR, just page 17 is the FIR, lordship may kindly see. Here, 6 persons is named in the FIR, he is not named. And the case number is mentioned here down below, your lordship will find that Badalpur 262, 2024. Now, next page, your lordship will find the forwarding report. He was arrested on 12/11/2024, and the FIR is of
Which
30
was which one? The next page? Next page is not.
page 19, lordship, page 19.
19. Ah.
He was arrested on 12/11/2024. And FIR date is 13/10/24, lordship. And in the forwarding report itself, lordship, at page 21, your lordship will find the date and time of arrest, that is 11/11/24 at 10:30 PM. Page 21, first line. Although he was forwarded on 12/11, but he was arrested on 11/11. And now your lordship may kindly turn to page 54. This is the notice under section 47, lordship, BNSS. No grounds are mentioned here in lordship. That only reference case number is there. No date, nothing has been mentioned. Only it is written that you are hereby informed that you are under arrest in connection with above reference case in non-bailable to police. So you are forwarded to the court. You may submit petition before the honorable court for your bail. So no grounds are mentioned here. Just I'm relying on That further your lordship will find that criminal law journal from our High Court lordship. And then paragraph 5, 6 are relevant lordship. Here lordship that it is discussed. Lordship may kindly say that paragraph 5 of this divisional judgment. The petitioner has not denied that the police officer has the power to arrest and accuse if he is suspected of a cognizable offense. But his submission is that in that case of the accused is entitled to the communication of full particulars of the offense under section 50, and in this case, this has not been done. The petitioner has specifically stated in his petition, supported by an affidavit, that communication of particulars of the offense has not been made to him till now, in spite of the orders of the Chief Judicial Magistrate to do so. This has not been countered either by the state of Assam, so by any affidavit. Sri Siarde, the learned counsel appearing on behalf of the state, submits that the police diary in his possession shows that particulars of the offense were communicated to the petitioner orally. We are unable to peruse the case diary in the face of the affidavit filed by the petitioner. There is no reason as to why respondent number 3 did not come forward to file a counter affidavit denying the petitioner's allegation. The provision of section 50 is mandatory and must be strictly complied with. A citizen's liberty cannot be curtailed except in accordance with law. Even if any communication about the offense was orally made by the respondent number 3 to the petitioner, we do not know what kind of communication was made. Whether the communication of the full particulars or mere section of the offense was told to the petitioner. In the circumstances, we hold that the arrest and detention of the petitioner by respondent number 3 was in violation of section 50 CRPC. They are illegal and consequently PR bond was cancelled, lordship. Now, second lordship, your lordship will see that Azir Ali case, lordship. Here also, lordship, I am relying on paragraph 16 to 26, lordship. All the provisions and honorable apex court judgments are discussed here, lordship. Paragraph 16, lordship, may only see. Here in paragraph 16, the grounds which was mentioned in that case is similar to my case, lordship. That your lordship will find it appears from record that on the day of arrest of the present petitioner, that is on 9/10/2024, the authority, that is the SI of police, had served a notice under section 47 of BNS to the petitioner and had obtained his signatures thereon. On careful perusal of the aforesaid notice, it appears that it is stated therein that the notice refers to Hazur PS case number so under section so. The notice further states as follows. You are hereby informed that you are under arrest in connection with above reference case as non-bailable to police. You are forwarded to the Honorable Court of Judicial Magistrate first class. You may submit petition before the Honorable Court for your bail. No other information was furnished in the paid notice which was served upon the petitioner. So thereafter, lordship, that Article 21(1) for section 47 of BNS, those are discussed, and that two honorable apex court judgments. And finally, lordship, he was granted bail because there was no mention about grounds in the section 47 level. And another judgment, lordship, order of our coordinate bench, which I am relying, lordship, that Josiruddin, that paragraph 17 to paragraph 22, lordship. And here another aspect was the lordship discussed, that also is discussed in the Honorable Apex Court Bihan Kumar judgment, that whether after filing of charge sheet, the initial remand order can be challenged or not. That aspect has been clearly dealt with in the present case, Lordship. And it is said once initial order is, Lordship, that remand is illegal, subsequent order will also go. And he is entitled to bail for violation of constitutional rights, Lordship. And that Lordship is ever, but still for Lordship affairs, I'm placing that to Bihan Kumar and Provin Prakash judgment, Lordship. So this is my humble submission to your Lordship.
Yes, Lord.
No, they are not agreed by the merit of the case, my lord. They are only, my lord, Article 21, my lord. So, my lord, since, my lord, it is a, my lord, such-that case, my lord. So, my lord, let the scan copy be called for, my lord, because the annexure 4, my lord. There are notice, this is not clear, my lord.
It's not clear, no?
Not clear, my lord. So, let the scan copy be called for, my lord, we will peruse the scan copy.
Lordship, the signature of the IO is there. And my signature was taken, that is also there. And this is the copy which they have furnished to me.
Annexure 4, page number 54, my lord. In fact, my lord, this is not the format also, my lord. So, let the scan copy be called for, my lord, to examine.
Or your Lordship can call for that notice also within a short date, Lordship. Because only the through email or also that or that notice can be obtained, Lordship.
The scan copy, my lord, it will come, my lord, within 2-3 days, my lord, because it is sent through, my lord, email, my lord, scan copy, my lord.
But this scan copy may not, you're saying that this, if CD not come, if CD does not come, then this notice may not be there also, no?
No.
Oh, no.
No.
They will
Only
be there.
notice,
It
only
will be there.
notice may be called if he is objecting. Within short date, through email, they can bring it.
Only notice, only notice.
Only notice that. They can produce.
Now, yes, Borwa, they are not going by the merit of the case, in fact.
Boys, they are,
See,
because it is already stated.
no, but only on the law point. But as you have raised the point that the 54 is not so clear.
47.
Sorry, no, 47 notice which I have annexed in 54. Only notice may be called for, then obviously through mail.
Through mail.
But from where it has to be called for, from the, it is already charge sheeted case.
Trial court, my lord.
From the trial.
Obviously
Special
from the
judge
trial
Karimnagar,
court.
Sribhumi.
Sribhumi.
Sribhumi. Now, earlier Karimnagar, now Sribhumi.
Heard Mr. A. Ahmed, the learned counsel for the petition. And also heard Mr. R.J. Borwa, the learned additional PP, appearing on behalf of state respondent. This is an application under section so and so in connection with so and so. The entire submission of Mr. Ahmed rests on the non-mentioning of grounds of arrest in the notice issued to the petitioner under section 47 of the NDPS Act. In that support, he also relied on some judgment. Next paragraph, Mr. Borwa, the learned additional PP, submitted in this regard that the notice which has been annexed along with the petition is not legible, and accordingly he insisted to call for the the original one or
One scan copy from the trial court by the registry.
If it is the same one, my lord, then I have nothing to submit, my lord. If
that
it
I
is the same
cannot
one
say
as
now.
per the-
This is the copy which were served upon them.
My lord.
It is their copy, isn't it?
Lord. Or your Lordship can call for that scan copy from the court. And Lordship may fix it on Friday, or we will by this time we will also obtain the certified copy of that this
You
document.
can obtain the certified copy
Yes.
also.
By next
Otherwise,
Friday.
you want to take scan copy of the entire record or what?
No, only this notice. Only this notice.
As huh? Scan copy of a legible scan copy of the notice issued under section 47 to the 47 BNSS to the petition. Mr. Ahmed further submitted it. In the meantime, they may also obtain the certified copy of the said notice. Call for the scan copy of the notice from the learned trial court so and so লিখি দিব, য'ৰ পৰা আছে, তাৰপৰা কৈ দিব। List on Friday, you have 60, list on Friday. Friday is
28 3 month.
28.
Online.
One tree.
That is lost. And in this case, my lord, the sheet was submitted showing the petitioner abscond lordship without any notice lordship. My lord, anyway, lordship, the petitioner wants to appear, my lord, some sort of protection lordship until my lord disposal of the application lordship. It may be disposed of, my lord, with certain, my lord, protection until my lord, his application may be disposed of lordship.
Here to protection, a question of interim protection will not arise, I think. Either it has to be disposed of or otherwise defective, whatever. Anyway, he was shown as an absconder.
Absconder. So, my lord, as the IU has paid for, my lord, issuance of non-bailable warrant lordship, I have attention lordship. So I kindly see this sheet.
How IU came into picture now?
My lord, IU has sought for, my lord, in the my lord, charge sheet lordship. I will kindly see charge sheet as at page 19 lordship. This is Magistrate Tribal lordship, page 19, except 3. It was, my lord, at page 21 lordship, page 21, second paragraph lordship. During investigation, the interrogation of witnesses and the seizure of the objectionable materials from the accused, we confirm their direct involvement in the incident. Based on the evidence, the case is well as founded under section so and so, so and so. As accused Mohammed Nasiruddin, son of so and so, remains absconding, it is prayed that non-bailable warrant may be issued against him. So he has an apprehension, my lord. This is a Magistrate Tribal lordship. The allegation is, my lord, in the name of police lordship. It demanded money lordship. My lord, I was not arrested lordship. 2 persons were arrested lordship. Against them, my lord, the charge sheet was submitted lordship. As well as the petitioner also lordship.
Have you annexed any order sheet?
No lordship. My lord.
How can we know that you are against?
My lord,
him?
because of, my lord, showing absconding, my lord, from the co-accused lordship, I could learn, my lord, that in charge sheet, copy of the charge sheet was, my lord.
No, you have not annexed any order sheet here.
No lordship.
How can we know that? Then how can we know that it's a charge sheeted case, his case is pending?
My charge sheet
Nothing is
there,
there.
lordship. Charge sheet is there, lordship.
Charge sheet there, after that where cognizance is taken, whether any process issued against you. How can we know? I mean, there's nothing in fact. Yes, for
Trial court will not go by the prayer of the IO, my lord. The IO has made a prayer to, my lord, issue non-bailable warrant against the accused person. But trial court will, my lord, go as part of, my lord, usual process, my lord.
otherwise also it's a view of
No,
the
I have
honorable
given
apex
remand
court.
to file application,
The
lordship,
police
then-
has the no authority to declare a accused as an absconder
My
in
lord,
fact.
my lord, absolutely correct.
So nowadays, I have generally seen that the magistrate used to issue initially summon. Obviously, if a non-bailable case or non-bailable, then if a session tribal case, then he, that may be executed or he may be arrested also. Even he appears before D. But otherwise, if it's a magistrate tribal case, if you have sufficient ground, suppose, that bail petition may be also be considered. But at present, we don't know whether you have issued with NBWA or PNA or I mean NBWA or summon or bailable warrant. It is nothing. Huh?
Record may be called.
So
Scan
the
copy
better.
Scan copy has to be called for.
You could have also furnished the certified copies. In fact, you have not furnished
Certified
anything.
copy of the charge sheet is filed.
No, not charge sheet.
Order sheet is not there, lordship.
Sachet file in the month of October 2024.
Yes, lordship.
Hmm.
Order sheet is not
Not
there.
in, my lord, whether trial court has.
I have also not in, my lord, received any notice, my lord, nothing is, my lord. Someone has.
Till now.
Yes,
Till now,
lordship.
you have not received. So I don't know. Basically, only based on the prayer of the IO that NBW should be issued. That is not the course. I think
That is why, my lord, in the meantime, my police, as per instruction, police, my lord, had come to the petitioner of lordship. My lord, during investigation, he was in Arunachal Pradesh, my lord, he was working there, my lord, from Lakhimpur.
you have a ground. You have a ground.
Yes,
That's what I'm saying.
That
So
is
scan
why, my
copy
lord, he
will
wants
come
to, my lord, submit application before the, my lord, magistrate lordship. Till then, my lord, some sort of protection.
No, we
process-
don't have anything before us. That's what is our problem.
Then, my lord, record may be called for. my lord.
Scan copy application. It is submitted by Mr. Ahmed that the case has already been charged sheeted, showing him as an absconder. In view of the post of Mr. Borra submitted in this record that the scanned copy of the case record will be required as no order sheet has been annexed by the petitioner. Scan copy of the case record along with the present status report be called for. The registry will do the needful. Yes, when it can be.
Any date, my lord. Convenience of this honorable.
We don't have any convenient date before Bihu or thing. It will be only after Bihu.
After Bihu, it will be long lordship.
We don't have, we will nothing to do, what to do.
As you lordship, like.
Yes, after Bihu days.
28.
28 will do or 28 for?
Lost. How like that?
17.
Now you are okay today?
Better. 528 application, my lord, for quashing of a criminal proceeding. So your lordship goes to the brief, my lord. Give them brief facts, my lord. The petitioner before your lordship is an assistant professor in a college in Nagaon. But the petitioner was facing sexual harassment at the hands of the principal. So she lodged an FIR against the principal. She also lodged a complaint before the harassment committee is there. My lord. The complaint was also lodged before that. Now, in that FIR, which was lodged against the principal, subsequently the charge sheet was also submitted and charges were also framed under 354A of the IPC. Now, the principal, on the day this petitioner lodged her FIR, on that day, subsequently, he also goes and he lodges an FIR saying that this petitioner had gone to his chamber, had threatened him that she would file cases against him. This is the facts of the case, my lord. Now, I'll take your lordship one by one to the documents. First, your lordship will kindly come to page 21. This is the FIR which was lodged by me, madam. May I read the FIR, madam? With due respect to all the members of the teaching council of our college, I am going to narrate and share my own personal humiliation and sexual harassment I have experienced from our principal, so and so, within our college. I have been keep fighting this battle alone. Maybe women can understand my weakness in this regard, but this time it has crossed all limits. I cannot tolerate more, and that is why I am sharing this today. Since his joining in our college as principal, he has been constantly harassing me. In any pretext, he came to our department, especially in the evening hours when normally no students are around, and then he tried to molest me. Situation became like that I even feared to stay alone in the department. I clearly told him to stay away from such abuses, but he misuses his authority as principal and unnecessarily harass me in departmental matters. We have taken a herbal garden under our department in so-and-so place, about 22 kilometers from our college. He one day took me with him in his car to investigate that garden. There exists a caretaker room in that garden. When we reached there, the caretaker was absent. He took me in that room in the pretext of showing something, and there he tried to have physical relationship forcefully. I strongly protest, somehow fled from his clutches. He repeatedly said sorry and bring me back to college again. I clearly told him that these things are not acceptable for me, and although I am in a temporary contractual post in so-and-so department, I will not compromise in these matters to keep my job. From this month onwards, he again started the same pattern. A post in the botany department was advertised last year, on which I have applied as per executive council by notification number so-and-so. That one post out of 5 posts of lecturer in Department of Botany may be appointed as lecturer by MSc degree holders of Guwahati University in Applied Botany and Biotechnology. But he has put the interview on hold for the last 18 months and keep asking me when I can go to Rangbang with him alone. It is only as if only when I will go with him and surrender myself to his advances, then only he can initiate the interview and help me get appointed. He repeatedly pressurizing and texting me to go with him. I have shared here one of the screenshot of such conversation with him. I have saved entire chat history with him. I have therefore put this complaint at your platform so that you can help me get justice. Now, this is the allegation which was lodged by me. FIR was registered, my lord, under Nagaon PSC 430. Your lordship will kindly come to page 32. Page 32 is the charge sheet, my lord. 32. Charge sheet has been submitted on my complaint, my lord. Charge sheet has been submitted under section 354A IPC. That your lordship will find the relevant part at page 36.
Second last para. Therefore, I submitted the case in CS under section 354A IPC against so and so, so and so. Now, page 38, your lordship. Charge sheet submitted, case registered. The summons issued, page 40, my lord. What's order? Page 41, my lord, charges went. This is, my lord, my case. Now, the lordship would have noted that this FIR I had logged on 8/4/2022 at 3 p.m. madam. Now, lordship will kindly come to page 46. The FIR logged by him against me, madam. May I read, madam? Sir, I have the honor to inform you that so-and-so college has been arranging an interview for appointment of an assistant professor in the Department of Botany on 9th April 2022. On 6th April 2022 at 12:15 p.m., one Dr. So-and-so, assistant professor, Department of Herbal Science, so-and-so college, who is a candidate for the interview, came to my chamber and threatened me on the matter of appointment. So-and-so has demanded that she should be selected by the selection committee, and if I do not consider her name for selection, she would file false complaint to the Honorable Governor and Honorable CM on me. She also threatened me to kill my image in the society by media publication on my character. Today, so-and-so was served a letter from the undersigned disqualifying her from the interview at her rules. Surprisingly, today at so-and-so place, she has published a letter on sexual harassment to malign my image in the society. In my life, I have not done any mistake with her. And since I have a responsible position in the college as well as a good family history. And he has also annexed that complaint, madam, at page 52. This is the complaint which I had lodged before the President and Secretary of the Teaching Council of the same college, madam, reiterating the same allegation. So I am a victim of sexual harassment. I lodged an FIR against him. That FIR gets charge sheeted. And on the day when I lodged the FIR, subsequent to that, he goes and lodges this FIR, saying that I went to his chamber and threatened him. And he has also tried to very conveniently, bring in this issue regarding the appointment, as if somehow because of that appointment process, I had done this. But this also, your lordship will kindly see, there is no need for me to do all of this. This terminates my, first of all, it debars me from appearing in the selection process. I come before this honorable court. Page 66, your lordship will see. Relevant portion of page 68, para 6. For the above reason, this court finds that order it is so-and-so prima facie would not be attracted in this case. In view as an interim measure, the court is inclined to direct the so-and-so college, respondent number 4, as well as the principal, respondent number 5, to permit the petitioner to participate in the selection process in respect of the post of assistant professor in botany of the respondent number 4 college in terms of advertisement dated 9/9/20. This order was also passed on 8/4/22. So there is no need for me to go and threaten him when I had already approached this honorable court and honorable court had allowed me to participate. But now what he does is that after this order is there, he terminates my contractual service, my lord. I again come before this honorable court. Your lordship will now come to page 70. Page 72 is the relevant portion. Second paragraph, madam. The said appointment was also approved by UGC in the pay scale payable to the petitioner. The UGC, while this order dated so and so, the pay scale was duly approved under the said program. Meanwhile, the petitioner was also given the responsibility as HOD of the HB College, Nagaon, Assam. The UGC assistance which commenced with effect from 1/4/12 was completed within 5 years from the date which was given effect to. As per the terms and conditions of UGC communication dated so and so, petitioner continued to render her service in the post. She was selected to the satisfaction of all concerned. During her tenure, in the an allegation of sexual harassment was made against the present principal by an assistant professor in the so-and-so department of the college. The complaint was submitted to the petitioner being the head of the department. Thereupon, the petitioner herself lodged a complaint of sexual harassment against the present principal by filing an FIR dated so-and-so.
The said FIR has duly been registered and police has undertaken investigation in respect of the allegation made. It is submitted by the learned senior counsel that allegation of sexual harassment made by another employee, namely so and so, is presently under consideration by the authorities of the college, and which complaint the petitioner has also forwarded to the police. It is submitted by the learned counsel that in view of the sexual harassment complaint allegations made by the petitioner, the principal, namely so and so, issued the impugn communication dated 7/4/22. And he referred to in his FIR that he had terminated me. So the honorable court says the principal, namely so and so, issued the impugn communication dated so and so, releasing the petitioner from her contractual service of the college with immediate effect. It is submitted by the learned senior counsel that this was apparently a backdated letter which was allegedly issued by the principal after the FIR filed by the petitioner was registered on 8/4/22. It is submitted to the impugn communication. Letter was received by the petitioner on 9/4/22 as stated in the paragraph 17 of the petition. That apart, the termination letter does not have the approval of the governing body of the college as required under rules. So subsequently, my lord, this notice was issued, and next paragraph, my lord, next page, last line, that order of termination was stayed, my lord. So when this color was trying to be given that because of this dispute which was there regarding my appointment, I had lost the FIR. I had already approached this honorable court, and this honorable court had already protected me in that regard. Now, otherwise, I'm clearly a victim of sexual harassment. I lodged an FIR. That is charged that this is clearly a case of counter FIR. Now, he does not even stop there, my lord. What he does is that he files a criminal petition before this honorable court. Your lordship will find that at page 42. Because there is a counter FIR, criminal petition is filed before this honorable court, and the proceedings get stayed. Now the issue is, I am a victim of sexual harassment. My case against him, which is charge sheeted, is stayed. Whereas now in his case, I am facing trial under section 448 and 506.
So what is this case? Your cognizance has already been taken.
In respect of me, cognizance has been taken under 448 and 506, my lord. Offences have also been explained. Now his case, the cross case, that gets stayed, my lord. I'm just relying on two judgments, my lord. This is, my lord, Salib alias Shalu alias Salim versus State of UP, my lord. Para 28. Para 26, the Bhajanlal criteria are cited, my lord. Para 28, my lord. At this stage, we'd like to observe something important. Whenever an accused comes before this court invoking either the inherent powers under section 482 of the CRPC or extraordinary jurisdiction under article 226 of the Constitution to get the FIR or the criminal proceedings quashed, essentially on the ground that such proceedings are manifestly frivolous or vexatious or instituted with the ulterior motive for wreaking vengeance, then in such circumstances, the court owes a duty to look into the FIR with care and a little more closely. We say so because once the complainant decides to proceed against the accused with an ulterior motive for wreaking personal vengeance, etc., then he would ensure that the FIR or complaint is very well drafted with all the necessary pleadings. The complainant would ensure that the averments made in the FIR complaint are such that they disclose the necessary ingredients to constitute the alleged offense. Therefore, it will not be just enough for the court to look into the averments made in the FIR complaint alone for the purpose of ascertaining whether the necessary ingredients to constitute the alleged offense are disclosed or not. In frivolous or vexatious proceedings, the court owes a duty to look into many other attending circumstances emerging from the record of the case over and above the averments, and if need be, with due care and circumspection above the averment, to try to read in between the lines. The court, while exercising its jurisdiction under section 482 of the CRPC or article 226 of the Constitution, need not restrict itself only to the stage of a case, but is empowered to take into account the overall circumstances leading to the initiation, registration of the case, as well as the materials collected in the course of investigation. Take, for instance, the case on and multiple FIRs have been registered over a period of time. It is in the background of such circumstances. The registration of multiple FIR assumes importance, thereby attracting the issue of wreaking vengeance out of private or personal grudge as it is. Here is also a case, my lord, where because we had lodged the sexual harassment complaint before the court and as well as before the police, this was a subsequent FIR which was lodged by the respondent. If such an incident had happened, he would have lodged an FIR far before that. Only after I lodged an FIR, my FIR gets registered, this is done. Now, another issue, my lord, regarding a legal issue, my lord. What happens when cross cases are there? Your lordship already knows that cross cases will always have to be tried together. Now, this is a case, if since both cases have resulted in a charge sheet, same it arising out of the same transaction, these will have to be tried together. Now, there's one case, my lord, one gets stayed, and this case the trial is proceeding. So, my lord, this is Mishrila's judgment, my lord. Your lordship already knows the judgment. It was, my lord, para 8. Correct. In the instant case, it is undisputed that the investigating officer submitted the challan on the basis of the complaint lodged by the accused Mishri Lal in respect of the same incident. It would have been just, fair and proper to decide both the cases together by the same court in view of the guidelines devised by this court in Nathi Lal case. Cross cases should be tried together by the same court irrespective of the nature of the offence alleged. The rationale behind this is to avoid conflicting judgments over the same incident, because if cross cases are allowed to be tried by two courts separately, there is likelihood of conflicting judgments. In the instant case, the investigating officer submitted challan against both the parties. Both complaints cannot be said to be right. Either one of them must be false. In such a situation, legal obligation is cast upon the investigating officer to make an endeavor to find out the truth and to cull the truth from falsehood. Unfortunately, the investigating officer has failed to discharge the obligation, resulting in grave miscarriage of justice. Here also, one has to be lying. Either the respondent is lying or I am lying. But I was submitted charge sheet against both of us. So, unless and until these two cases are tried together, my lord, the truth will not come out, and that is the mandate of law. So, at this stage, my lord, I humbly pray that notices go to the respondent, records be called for, my lord. This matter may also be tagged with the criminal petition 966 which they have filed. Until then, my lord, the proceedings may be stayed. Both proceedings, let the proceedings in both cases remain still. Both cases, criminal petitions be heard together, and whatever be the outcome, my lord. If you require, both of us will go and face the trial, or if required, one or the other case may get cross-tried.
Both the cases ended in Sarsit, my lord. And my lord, the FIR lodged by the petitioner, my lord, that was also, my lord, registered on the same day, my lord. And the FIR lodged by the opposite party, my lord, that is also registered on the same day, my lord. And both the cases ended in, my lord, in Sarsit, my lord. Now, my lord, at this stage, my lord, that notice be issued, my lord. Notice to let the opposite party appear, my lord. After that, lordship may, my lord, consider it the interim pair, my lord.
17, at number 17. Mr. S. Nawaz, the learned counsel for the petitioner, and also heard Mr. R.J. Burwa, the learned additional PP, appearing on behalf of state respondent number 2. This is an application under section so and so in connection with so and so. Issue no here you have made party
Respondent number
issue
2.
notice to the respondent number 2 to registered AD and as usual process. No formal notice is required to be served on state respondent number 1 so and so. Also call for the scan copy of the LC. Further, Mr. Nawaz is heard on the interim prayer, and it is submitted by him that the present petitioner is a assistant professor in contextual, but she is was working as an assistant professor in Department of Botany,
Department of Herbal Science and Technology
Herbal Science and Technology
in Anandaram Dhekial College, Nagaon.
in Anandaram Thekiaphukon College, Nagaon. The principal of the said college, the present informant, used to harass her, and on several occasions, however, she remained silent for some days. But when it was in extreme condition, she lodged an FIR before the Nagaon police station, which was accordingly registered
as Nagaon PS case 430 of 2022.
as Nagaon PS case number 430 of 2022, and which was subsequently ended in charge sheet and against the present informant under section 354A IPC. Charges were also framed. against the present petition under the said section of law. If order submitted and after filing lodging of FIR by the present petitioner, the principal of the said college, that is the respondent number 2, also lodged an FIR against the present petitioner with some allegation of threatening and with the allegation that he entered into his room and threatened with dire consequences if she is not given to post as in the post of the professor. They said FIR is also registered accordingly and the case is charged sheeted. However, the FIR lodged by the present petitioner was accordingly stayed by this court, and the White order dated 13/8/2024 in criminal petition number 966 of 2024. If further submitted that the present petitioner is a victim of sexual harassment and as a counter, the present petition, the present respondent had lodged the FIR against the present petitioner with some false and concocted allegation. And he also, first he used to terminate, no? He passed the order of termination.
Releasing her from the court.
Was the order of termination, releasing her from the contractual job. But as when she approached by the this court, the
Read petition WPC 2640 of 22.
but
Page 70 million.
but and the against the state's termination order, she approached the this court with a writ petition which is registered as WPC 2640 of 2022, and wherein the this court stayed the order of termination against the present petition. Accordingly, he submitted that the false case is lodged against the present petitioner and prayed that it may be stayed till next date of till the disposal of the present petition poster. Next paragraph. Mr. Borwa, the learned additional PP submitted in this regard that both the cases are already been charge sheeted, wherein the allegation of threatening and trespass is brought against the present petitioner, and accordingly he submitted that the case scan copy of the case record may be called for.
Trial has also comments, my lord.
Huh?
Trial has also comments, my lord. Both that.
Agata Likhita, subsidiary, and trial has also been commenced in both the matters, and accordingly he insisted to call for the scan copy of so and so. Next paragraph, considering the entire facts and circumstances, but stay review. Okay, your case will be stayed.
I'm deeply aware.
List after 3 weeks.
The two of the subsidiaries.
It is a writ petition, my lord, so government advocate will have to appear, my lord. Let's see.
Government advocate is so informed or not yet?
They have served copy to us, my lord. So they have to serve the copy to the government advocate civil side, my lord.
Mm. Why this rate is here?
Only because lordship, there is a bar under this interlocutor order. I am coming against order passed in exercise of power 311 lordship, CRBC. And that is an interlocutory order, so which has been repeatedly stated by a High Court, Supreme Court lordship. And the interlocutory order against interlocutor, no revision lies. Since it is specifically barred under the CRPC, therefore, for it to also cannot come lordship.
That case, he could have filed by she or washing or setting aside of the order, you could have come.
No, if these are, lordship, there are some.
How read will be there.
Yes, except the power under 227, Lordship.
Mm.
397, 1, there is a bar, 2, there is a bar. 482, because since revision cannot be, there is a section which is expressly bar revision. So the argument is that 482 cannot, and any application under 482 cannot be entertained. Therefore, only last resort is.
There are some in 482, section 482 itself speaks what is the situation, how, why, abuse of process of if
Yes,
any illegal. These are the things. So if that is there, so obviously your interlocutory order, so that is barred. Criminal revision cannot be there, but why not criminal petition?
Yes,
And
that is,
through
that
this
is,
writ
that is,
petition, what are we praying for?
that is for setting aside the order which was passed in exercise of power under 311.
Okay,
But I will give it, there's a written judgment by.
Judgment will, but suppose state or government or advocate কোনোবা আছিল নেকি?
They can serve a copy to them, madam. They have not served copy, that is why they have not appeared.
We have not served the copy to the government side, na?
That is a mistake, Lordship.
So let them serve this copy to government side, one, civil side.
Serve a copy, I think, otherwise,
Yeah. Let it be tomorrow.
so there was an order of 311 only.
Yes, Lordship.
That is
At,
the
at the
order.
stage of our judgment, Lordship. Case was posted for judgment 3 times, Lordship. On the third time, the order was passed under 311 for further examination of PW1, Lordship. And that too without
So by
assigning.
that time already PW1 is re-examined or still pending?
No. Today is the date fixed for, but we have filed an application for adjournment showing this
Achha.
petition pending.
Achha.
Court has, my lord, initiated this proceeding, my lord. Lordship may kindly see the page 29, my lord. I do not have found any manner irregularity in this order, my lord. This is a very clear order, my lord. This is one of past 40 ends of justice, my lord.
Yes. What the Supreme Court says, Lordship, within the blanket cover of ends of justice, ambiguity, this will not sufficient reason. Reason transient and valid reason has to show. If there is any ambiguity to a hard extent, how if it is not recalled, how it will affect the fair trial, Lordship. That has to be stated in the order because
It seems that there is no such.
there's no such option. They simply says that this evidence of PW1 is ambiguous for ends of justice. So,
But their petition, what was it cleared in the
no,
petition?
it is by at the instance of court, no petition.
By the instance of court?
Court.
Oh, then too it's what to do?
No, power under section for exercising the power under 311, Lordship. It is not that which has the
311, the court has ample power, in fact.
Yes, but
While analyzing the, because yes, while analyzing the case record and this relevant evidences, most probably court find
when
that it is required for re-examination. There are maybe some, I don't know, what is this
yes,
not
there
here?
are maybe Lordship, but in that event also court has to so stated cognate reason, tangible reason. Any ambiguity in the order itself. Where
So there was no petition from any.
petition.
It was the court who took the that decision so moto.
It is necessary because some ambiguity is there for complete justice. I have to exercise that power. But what ambiguity is there? How, if not taken, it will affect the fair trial. Nothing has been reflected.
This is very clear. Lordship may kindly peruse, my lord. Today was fixed for judgment. However, while going through the record, it reveals that the evidence of the victim recorded as PW1 is very ambiguous. And on the said evidence, it will be difficult to arrive at a just decision of the case. What needs more, my lord?
It needs more because
Okay, anyway, when I'm going to hear the matter, so will not waste time here. Mr. U. Datta, the learned counsel for the petition. So you are going to appear or copy?
Civil side will appear.
Here, so and so, and also heard Mr. R.J. Purva, the learned additional PP, but it is submitted by Mr. Purva. That copy is wrongly served to the present, the state, public prosecutor instead of furnishing the same to the government advocate. Accordingly, the the petitioner side is hereby asked to,
So we have to correct that process also, madam.
yes, yes, serve
Because
the
the state
copy.
of Assam through public prosecutor, madam. That is
Serve
correct.
the copy to the government state government advocate, state of the government advocate, and it is also seen that the cost title is also needs to be corrected, wherein the the petitioner, the public prosecutor, state of the public prosecutor is state is made a party respond number 1 through the public prosecutor. Accordingly, Mr. Dutta is hereby asked to take necessary step to amend the cost title of the petition, and accordingly the government advocate to represent this accordingly the state may be represented by the government advocate, and in the meantime the copy of the petition may be served to the senior government advocate. List according how many weeks you need? 2 weeks?
Friday, because otherwise
Friday.
on the
Friday, it's not possible. Friday.
and in the next week.
Next week is also not possible. Anyway, can in next week. What to do? I think we are in very difficult position.
Yes.
Everyone is asking for date,
Yes.
and date.
No, my difficulty
So
is
it's
that
a very
proceeding is
difficult.
proceeding is
How
there.
how can you manage all dates? We cannot now. It's not possible.
Today somehow they have managed in the court below by filing application also.
7-4. But how can you say that the court will do these things, because court is to pass the
Lordship would be
for
pleased to go
for the
to-
ends of justice. In fact, court is there.
Yes,
So
this is the
pass.
this is the judgment.
Yes,
Lordship.
and
I'm-
how can you blame a court? In fact, it is a court
Yes,
who
Lordship,
took to
before-
pass the order so moto. In fact.
No,
Okay.
there are certain judgments, Lordship. We get basis. If Lordship want to scrutinize, then I am submitting the judgment.
No, on the next date. No, otherwise you are against the order of a court. That is the so moto order. I am not
Yes, yes.
otherwise. Then how? It is the court to decide the case, and obviously.
Lordship, Supreme Court says that reason has to be stated, and that is
That is understood, but the court generally when pass the order so moto, there has to be some reason. There has
Yes,
to be
Lordship,
some
but-
reason. Otherwise,
no. The
yes,
Supreme Court says that the order evidence is ambiguous is not a ground. For the ends of justice
on the
is
basis
not a
of
ground,
which,
not a
on the
reason.
basis of which the order will pass now, the judgment will pass, because evidence of the victim is very vital. She's a vital witness
Lordship,
of the entire prosecution
I'm
case.
admitting to
So
saying
her
that,
evidence
but-
is suppose if ambiguous, then how court will pass the order?
No, the requirement which Supreme Court says there, two things says.
Maybe.
Number one, ambiguity in the evidence is a blanket bracket statement. It will not serve the purpose. The reason, it cannot be a reason. And secondly, for the ends of justice, it cannot be also interpreted to be a cognate tangible reason.
Whatever, but
That-
it's an
that too.
order of court. It's a so moto order of court. So we are listing it on before we have somehow we manage the date on 7-4.
Obliged.
এটা কিবা হেৰি pass কৰিছে নেকি? Affidavit আহিছে ন?
Please, your Lordship.
Affidavit, we received the affidavit.
Yes, Lordship, I have filed the additional affidavit, it is on record, Lordship. Yes, Lordship, at page 24 is the charge sheet, I have been shown as a offender.
You have filed the charge sheet here.
Lordship, page 27 is the type copy, Lordship. The second paragraph, Lordship will find. This is Gary, so and so, is absconded accused. Roshumi Gary. This is the petitioner. And the subsequent orders also I have, earlier orders also I have annexed, Lordship, in which bailable warrant was, bailable warrant of rupees 500 was issued. Thereafter, Lordship, thrice it was issued. Thereafter, Lordship, non-bailable warrant of arrest has been issued. That is, I have annexed in my petition, Lordship. That is on 9/10/23 and 5/12/23. I will appear, Lordship, because since I was kept in under confinement, which I have stated in my paragraph 8, by my husband to get divorce in expert in divorce order in title suit D number 35/23. That Lordship, I all on the other day I placed that judgment.
What was the title suit number?
Title suit number, title suit D within bracket D number 35/2023. And the date of
Order, ex parte order passed on.
passed on lordship. On 22/10/2024. After I was released from the confinement lordship, only then I could able to come to know that police is searching for me. I'll appear before the Lanet court below lordship. In the meantime, I may be protected lordship.
So NVW were issued from which date?
On 9/10/23, then 5/12/23. That is that page.
9/10/23.
Lordship.
1923 order is not annexed
At
by you.
page 14 in the main criminal petition.
Page 14.
Lordship.
So here also again you have not annexed a whole entire order sheets.
Yes, in
Part, part,
in
part,
additional
part.
affidavit, I have an entire.
Not entire, that's what I'm asking. Here we have received 4/24/7. Next date is 14/8. 14/8 is missing. Again 12/12/2020. So you have not annexed.
So all the whatever I had, all I have annexed lordship. Up to page 42.
Here is Aadhaar, is Aadhaar.
Earlier bailable, then thereafter non-bailable lordship. Then proclamation.
It's a commodity name. It's a commodity. Full papa here say by to lagi bon. This will take it to solid is to go work then to take it.
Page number 16 is a my PNA order, my lord.
Yes.
Whether after my lord issuing of PNA, my lord, whether this honorable court has power to my lord. Pass the my lord order, my lord, issuing PNA, my lord. This is my humble submission, my lord.
I'm not for watching lordship may recall the orders.
So that they have to, my lord, file some sufficient ground, my lord, because PNA has been issued, my lord, because he has not appeared.
Yes, PNU was issued, but it was not acted upon because there is no property in my name. And that is order dated 17/9/24 at page 17 of the criminal petition lordship. Attachment issued against the accused person query returned with report that the accused person could not be found and there is no property in the name of the accused person, hence order of attachment could not be executed. Now I am ready to appear lordship because the trial is going on. I am ready to appear lordship only.
So have you seen it is not complete, na? Order sheets?
Yes, lordship. Those which I have annexed everything lordship from page
They have to put
24 to 42. From page 24 to 42, I have annexed lordship. And
Order sheets are not complete, na? From month of July, you again jump to December. See?
14/11/22 was cognizance was taken. Thereafter 16/12/22 summons were issued.
After 12/12, my lord, directly, my lord,
Yes.
4/4/2024, my lord.
Hmm.
It is not, my lord,
10/1/23.
systematic, my lord.
Then 10/1/23 is the order. Then 13/2/23, another order bailable warrant. 13/3/23 bailable warrant. 4/4/23 bailable warrant. Then 9/5/23 bailable warrant. 2/6/23 TM was NBW issued against the accused person not returned yet. Issue fresh NBW. Accused person says NBW issued to other accused person on 28/6/23 person not returned yet. Issue fresh NBW. Accused so. It also states NBW issued against the accused person not returned yet. Issue fresh NBW that is 24/7/23.
In spite of you were asked to produce all the order sheets, but again you have did the same mistake, na?
And 12/12/24 is also there. Also.
those which were supplied to me, Lordship, but these were finance, Lordship.
So you could just check these order sheets. And these are all missing. Who applied for the certificate copy? To save money or what?
No, Lordship.
Then why it is not completed? You are Rusumi, na?
Yes.
So the order put to challenge is 17/9/2024.
9/10/2023,
Huh?
9/10/2023, and 5/12/2023,
9/10/23
and 5/12/23.
and what about 17/9?
17/9, Lordship.
But I have checked the orders, against you, the NBW was issued on 9/5/2023.
Yes.
And 5/12,
2023.
PNA was issued. 17/9. And you have annexed the orders of 17/9?
Yes, Lordship. At page 17.
Page
Page
17.
17 of the criminal code.
Heard Mr. Ardhar, the learned counsel for the petitioner, and also heard Mr. R.G. Burwa, the learned additional public prosecutor for the state respondent. And in pursuant to order dated 21/03/2025, the additional affidavit annexing the charge sheet and the other orders are being annexed along with the additional affidavit. This is an application under section so and so in connection with so and so against the order of 9/10/2023, 5/12/2023, and 17/9/2024, whereby the NBWA, PNA, PNA, and the was issued PNA, no, again, sorry. Against the order 9/10/2023, 5/12/2023, whereby the order of 17/9 to Katidiva, whereby the NBW and PNA was issued against the present, respectively against the present accused petitioner. Subsequently, by order dated 17/9/2024, the case was filed against the present petitioner by issuing standing warrant against her. In next para, it is submitted by Mr. Thorpe that the present accused petitioner was not aware about the pendency of this case, or nor she was pendency of this case, nor she was ever searched by police during the investigation of the same. Her husband,
Biren Goyari.
Hmm?
Sri Biren Goyari.
Sri Biren
Confined.
Goyari, she was confined by her husband, Sri Biren Goyari,
So one, Mrs. Niru Bosumatari,
in house of one Mrs. Niru Bosumatari
Udalguri town.
in Udalguri town, only to get an ex parte order in a divorce suit filed by him, which is numbered as TSD
Being 35
35
of
of
2023.
2023. And after order of ex parte passed on 22/10/2024 only, she was released from her confinement, and then only she came to know about the pendency of this case as well as issuance of NBWA and PNA against her. First, however, she is ready and willing to appear before the learned trial court below to face the trial on each and every date to be fixed if she is granted with the privilege of bail. Next, para Mr. Borwa, the learned election PP, submitted in this record that the present petitioner was shown as an absconder in the charge sheet, and after exhausting all required formalities, the court had to issue PNA against the present accused petitioner, and subsequently a case against her had to be filed by order dated 17/9/2024. He raised objection and submitted that once PNA is issued against the present petitioner, the order cannot be set aside and quashed. First, next para. Considering the submission made by learned counsel for both sides, I have also perused the case record and the annexures file along with the petition, especially the order sheets, wherefrom it is seen that the NBW was issued against the present petitioner since 9/5/2023, and subsequently on 5/12/2023, the PNA had to be issued, and PNA had to be issued against her. However, considering the report of the executing officer, the court had to file her case against her by order dated 17/9/2024, and thus the case was split up, and the case for the co-accused was proceeded further. First, however, from the submission made by the learned counsel for the petitioner, and considering the fact that she was under confinement till the disposal of TSD 35/2023, wherein the husband of the present petitioner got a ex parte decree order in his favor, I find that there is sufficient reasons has been brought by the petitioner for her non-appearance before the learned trial court below. Considering this aspect only, I find it I find it proper to allow the present petitioner to appear before the learned trial court below with an application for bail, appropriate application for bail, which may be considered in accordance with law. Till then, the execution of NBWA and PNA issued against the present petitioner will remain stayed or suspended. She will appear for 10 days. Within 10 days, you appear.
Deeply obliged.
Appeal hearing, item 29.
Okay. 20.
It is the lordship.
Yes.
Madam, before I start my argument, madam, I'm submitting the order, certified copy of the order sheets, madam. Where all the up-to-date orders are there. Order sheets, madam, of this case. And in this case, the petitioner was arrested along with the husband on 22/10/2023, madam.
22/10.
22/10/2023, madam. She was arrested along with her husband on an allegation that some contrabands were recovered at their house, which weighs to commercial quantity, madam. And thereafter, madam, they were forwarded to judicial custody. Now, on the same day, they were forwarded to judicial custody, and madam, thereafter, the charge sheet was laid against the present petitioner and her husband on 16/2/2024, citing as many as 11 witnesses, madam, to prove the case. In the 17/1/2025, madam, the London trial court was pleased to frame charges against the present petitioner. I have, madam, supplied the order sheet. Now, madam, in this case, what happened, madam, I have stated in paragraph 6, the police, madam, initially came looking after her husband, madam. He was not present at the house. Subsequently, madam, he came in. When he came in, my lord, the petitioner along with her two minor daughters and one children were kept in one room. And that took him to some other room, my lord, where they found the contraband. Now, why they were taking him to, my lord, the police station, she resisted, my lord. That is what she resisted, my lord, and started some hue and cry, my lord. Thereby, my lord,
She registered for what?
arrested, my lord, a village government, my lord. She started, my lord, created hindrance in my lord, performing the duty, my lord. So the police also took her to custody, my lord. Now, my lord, another aspect of this lordship, calls for consideration, my lord. I have like mark in the trial court record, my lord. Although, my lord, I was not able to annex the same. When they were arrested, my lord, petitioner was arrested, my lord. She was not even informed of the grounds, my lord. It is only written, my lord, that I have flag mark, my lord. A green flag, lordship will find. Only you are hereby informed, my lord, that much of information was provided to her. And in that regard, my lord, there are catalog decisions, my lord, which settles the position. In fact, there are lordship, very recent judgments. Lordship has got it, my lord. Yes. So this is, my lord, this is the bedrock ground of this case, where, my lord, she ought to have been, it is the constitutional mandate, my lord, where she ought to have been, my lord, supplied with the grounds of arrest, which has not been done admittedly in this case, my lord. And I'll just supply the Vidhan Kumar's judgment, my lord, in paragraph 29. 21F is relevant, my lord, for lordship's consideration, my lord. Yes. Paragraph 21, my lord, in conclusion. May I just read, my lord, paragraph 21, conclusion F. When a violation of Article 22(1) is established, it is the duty of the court to forthwith order the release of the accused. That will be a ground to grant bail, even if a statutory restrictions on the grant of bail exist. The statutory restrictions do not affect the power of the court to grant bail when the violation of article is established, my lord. So, my lord, this, from the record, it is very apparent, my lord, that the constitutional mandate was not at all followed. Now, another aspect, my lord, paragraph 16. Although, my lord, after filing of charge sheet, it has been raised. Paragraph 16, my lord, the position has been cleared by Honorable Court, also Apex Court, my lord. May I just read, my lord? Paragraph 16, my lord. An attempt was made by the learned senior counsel appearing for the first respondent to argue that after his arrest, the appellant was repeatedly remanded to custody and a charge sheet has been filed. His submission is that now the custody of the appellant is pursuant to the order taking cognizance passed on the charge sheet. Accepting such arguments with great respect to the learned senior counsel will amount to completely nullify Article 21 and 22 of the Constitution. Once it is held that the arrest is unconstitutional due to the violation of Article so and so, the arrest is itself vitiated. Therefore, continued custody of such person based on orders of remand is also vitiated. So once lordship finds that the initial arrest is, my lord, is illegal and without following the due process of law as mandated by the Constitution, my lord, the petitioner is entitled to
her personal liberty. And now, my lord, another aspect, my lord, for consideration is, my lord, the incarceration part, my lord. There is already, my lord, she is already in custody for last 1 year, 5 months, 3 days, my lord, 520 days as on today. As on today, and my lord, next date is fixed on 12/4/2025 for examination of witnesses, first witnesses, my lord. Charges has only framed on 17/1/2015, my lord. And in the month of April, my lord, 12/22/2025, it is fixed for evidence. So from that aspect also, lordship can visualize, my lord, the trial, completion of the trial will take some reasonable time, my lord. And in that regard, my lord, I'll just place 3 small, my lord, judgments of, including lordship's order, my lord, which will be passed very recently. The first one is, my lord, Vishwajit Das. That is our High Court rejected, my lord. He came for it was a matter under commercial quantity, and he was just behind the bar for 300 some days, my lord. So our High Court did not entertain his application. My lord, when he went to Honorable Apex Court, the Apex Court was pleased to grant him, my lord, page 2, my lord, fine. He was in custody for 1.5 years, my lord. And considering the fact that he's a driver of the vehicle and he has no other criminal antecedents, and also the period of incarceration of the petitioner, we are of the opinion that a case of bail is made out for the petitioner. So accordingly, my lord, bail was granted, my lord. And one aspect, lordship also kindly note the criminal antecedent, my lord. In many of the cases, my lord, Supreme Court also considers the criminal antecedent, my lord, as one of the factor, my lord, while granting bail in such cases, my lord. And my lord, the second one is Jahid Hassan. There also, my lord, this petitioner, lordship will find at page 2. He was in custody for only 11 months, my lord. Only 11 months. May I just read, my lord? The petitioner is an accused in FIR number so and so registered at Murshidabad for the offence punishable under section 21C of the NDPS Act. Learned counsel for the petitioner stated the petitioner has been in jail for 11 months, has no criminal antecedents, excluding this case. Considering the facts and circumstances, we are of the considered opinion that the petitioner is entitled to be released on bail. So this is one of the and third one is Dhirendra Malad. This is also our High Court rejected the bail applications, my lord. And may I just read, my lord, 2 paragraphs, my lord, the principles of. We are inclined to set aside the impugn order only on the premise that the trial is yet to begin and the appellant has under incarceration for 17 months. Thus, on the principle of right to speedy trial, we are inclined to grant bail to the appellant. So these are right to speedy trial, my lord. Right to speedy trial, lordship knows the section 36 of the NDPS Act provides, my lord, that very right, my lord, to get a speedy trial. So accordingly, my lord, the Dhirendra Kumar was also granted bail in this case. And fourth, my lord, is Aisha Begum, where lordship has considered, my lord, prolonged incarceration part, where a petitioner was behind the bar for 412 days, my lord. And she was in the jail, my lord, along with her infant. And lordship, paragraph 16 and 17 relevant are in the. May I just read, my lord, paragraph 16. In the instant case, it is seen that there are some materials available in the case that and on the basis of which the investigating officer has also filed a charge sheet against the present petitioner showing her involvement. But it is also true that in spite of filing of charge sheet on 2/2/2024, the prosecution could not examine any witness. Though it is a fact that the petitioner is behind the bar for more than 412 days, thus in such situation, it is unlikely that the case will be resolved in near future. So, my lord, thereafter, lordship was pleased to grant the lady, my lord, putting some stringent condition, my lord. So, pleased to grant her privilege of bail. So, lordship, considering the aforesaid aspects, my prayer at this stage, lordship, I kindly consider my prayer for a conditional liberty with any stringent condition, my lord. And further, my lord, I am a local resident. So there is no reason for abstaining this lady, my lord, not to face the trial. Her husband is still in jail, my lord. She has 3 little minor, 2 minor daughters and 1 son is there. I have annexed the birth certificate also. There is no one to look after, my lord. In the meantime, my lord, just her father-in-law, my lord, who was the only male member in the family, he also passed away, my lord. I'll just place the, my lord, death certificate of the father-in-law. 4/5/24, he died, my lord. At page 25 of the forwarding, lordship will find the deceased name against her husband's name, my lord. Mojiruddin, son of Haji Abdul Salam.
My lord, it's a commercial quantity, my lord. 1 kilo 263 gram, my lord. Yaba tablet was recovered from the possession of both the husband and wife, my lord. It is, my lord, clear from the page number 42, my lord. Lordship may kindly peruse, my lord. Page number 42, my lord. Arrested, my lord, and during investigation, my lord, sufficient materials were found against them, my lord. And even the FSL report also, my lord, it was tested positive for methamphetamine, my lord. Now, my lord, in this case, my lord, the charge sheet was submitted on 16/2/2024, my lord. And my lord, charges frame on 17/1/2025, my lord. There was some delay, my lord. Now, my lord, as far as my lord, 47 notice, my lord. That Lord CVC, 47 is not a new thing, my lord. It was there from, my lord, from the when the IPC was there, so the 47 was there. Now it is 47, my lord, earlier it was 52, my lord. Now, my lord, nobody has, well, challenged that, my lord, that ground over has not been mentioned, because in all 47 notice, my lord, nowadays, it is mentioned that, my lord, you have been arrested in connection with such and such case, my lord, under section so and so, my lord. But it is not mentioned that from your position, my lord, this narcotic substance was recovered. That was not mentioned. My lord. Otherwise, my lord, in each and every case, my lord, ground of arrest has been mentioned, my lord. But after coming to the, my lord, this Kobir Purkast and Vihan Kumar case, my lord, Supreme Court has specifically mentioned, my lord, Honorable Apex Court, my lord, that ground of arrest, my lord, only case number will not do, my lord. You have to mention, my lord, what is the actual allegation against him, my lord, and why he has been arrested. There has to be, my lord, mentioned, my lord, in written, my lord. So, my lord, this law, my lord, it is clear, my lord. I am not aware. Opposing view, my lord, because, my lord, it is mentioned, my lord, in the 2010 judgment, the Honorable Apex Court, my lord. Now, regarding, my lord, long incarceration, my lord, they have completed only 1 year, 5 months, my lord. Now, my lord, Supreme Court, my lord, in the last case, it was, my lord, SLP criminal, my lord, that was judgment passed on 4/8/2022. It was considered, my lord, 1 year, 6 months, my lord. Now, my learned friend, my lord, came to this document, my lord, where, my lord, Supreme Court considered in
The very
1.5 year, my lord, it is same, my lord. That means, my lord, 1 year, 6 months, my lord. In other case, my lord, 11 months Supreme Court is considered, my lord. So this part, my lord, I leave it to your lordship, my lord, with my objection, my lord. Because these are the very commercial quantity, my lord. Although, my lord, Article 21 will prevail, my lord, because the 47 notices as far as what Skengopi has said, my lord. The 47 notice, nothing has been mentioned, my lord. So that part has to be looked into, my lord. Because 47 notice is not a old new thing, my lord. It was earlier also, it was there, my lord, but from the Vihan Kumar case, my lord, it has to be specific, my lord. On what basis or under what case, my lord, or what has been found from you, that has to be mentioned clearly.
In fact, our High Court was the first one to interpret the section 50, my lord, in Amit Kumar Sharma case. Okay. 76. 76.
My lord, because, my lord, The statute has provided, my lord, 360 days, my lord. 180 days is, my lord, in normal court, my lord, and if, my lord, the further investigation is required, my lord, they can, my lord, file an application for 360 days. my lord. So, about 11 months, my lord, what is already passed on, my lord. That's
My-
our individual, lord.
In such case, my lord, I'll relying on Lordship's judgment that Aisha Begum, my lord, where Lordship has in 412 days, my lord, consider that as a prolonged incarceration. my lord. Deeply of this.
Lordship will dispose of money.
Yes, this. These are all receipts.
Yes, my lord, certified copy of the other sheets. my lord.
Past the order.
My lord.
Will lend the orders.
Yes, yes, my lord. I'm deeply of that.
May I please stop, sir? Actually, this was a regular bill application involving NDPS of a commercial quantity. And trial court has rejected bail application. Also, will find their order from page 42 also. In this case, lordship, charge has already been framed. Lordship, copy is not available with you. Recently, charge has been framed. And
Charge
considering the
recently framed.
charge has been framed.
So we have any that trigger, this certificate copy is there? I mean, scan copy is there?
Scan copy received, my lord. As per the scan copy also, my lord, the case was fixed on 5/2/2025 for consideration of charge, my lord. That was the last order.
Then we need that.
Because
But as per your instruction, charge has already been framed. You're Mr. S.K. Singh. S.K. Singh, the learned counsel for the petitioner. And also heard Mr. R.J. Burwa, the learned additional PP, so and so. It is submitted by Mr. Singh that as per his instructions, the charge has already been framed against the petitioner, but he could not produce the certificate copy of the order of framing charge. First. Next para, Mr. Burwa also submitted in this regard that the scan copy of the case record is updated till 5/2 not 5/2, no? It was fixed for. Not updated, and the last date was fixed on 5/2/2021.
2025 was the last order.
Last order was 22/1/2025, whereby the case was fixed for framing of charge on consideration of charge on 5/2/2025. But thereafter, there are no updates in regards to this and so. In view of this, the registry is hereby directed to call for the present status report. Present status report will also do, I think, present status report of the case. Do we read up in view of this, let the present status report of the case record be called for, registry will do the needful. Can I get it? Huh? Registry will do.
lordship, fix a date, lordship. After period, lordship, no problem.
29/4.
Obliged.
May I please, Lordship? Can it be on 3rd April, my lord?
Huh?
Can it be on 3rd April? The personal difficulties, my lord.
3rd April.
3rd and
Otherwise,
4th
you have received any case diary?
Case diary received.
Case diary received.
My lord, let it be, my lord, on 10th of April, my lord. Because, my lord, the IO, he required the, my lord, case diary, my lord. It is pending before the honorable court, my lord. So some other So we'll
Your
send back the case
petitioner,
diary, my lord, we'll
petitioner is in, behind the bar since when?
Since 3rd February, my lord.
3rd February of this month, this,
This year.
case pertains to which case section?
UAPA Act is there.
Huh?
UAPA.
Oh, UPA. Oh,
So we'll fix it on my lord, 2nd week of April, my lord, or subject to convenience of this honorable court, my lord. And we'll send back the case diary and my lord, all up to date.
second wave of April, since you want to fix it on 10th.
No, my lord, I'm not praying, my lord, he is praying, my lord.
And 4th, my lord. Sure, 3rd or 4th, my lord.
So, my lord,
Till 3rd, can you detain the case diary?
look, we have to send back the case diary, my lord, we required, my lord, we'll call again, my lord. No, let it be on 8th, my lord, then.
8. So you want to return back the?
We'll return the case diary and call up to date.
The request made by the learned counsel for the petitioner. Case is adjourned, however, it is submitted by Mr. Burva. The learned additional PP, that case has already been, no, the CD is received. However, there may be some difficulty on their part to retain the CD as the case is under in process of investigation. Let the CD be returned and call for the updated one. Fixing 8/4/2020. We're fixing it on 8.
33.
May I please announce? 43 bail application, my lordship. Charge sheet. Proceeded matter, my lordship. The previous scan copy was false.
False. Most probably you have received also. Can copy has been received.
Think we received, my lord. Other co-accused have been enlarged on bail, my lordship. And the petitioner was arrested on 21/10/2024, 155 days behind the verdict date. Other co-accused. What is honorable court?
পাঁচটা ভিতরে পাঁচটায় আছে পাঁচটার ভিতরে পাঁচটা সাইডে
আরো এজন আছে। পিছনে arrest করেছেন।
No, there are some difference. In fact, some of the accused persons are may not be directly involved, but your petitioner, present petitioner, who is he?
He was also in the main conspiracy.
No, my lord, he is the main person, my
He's
lord,
the
who
main-
killed the my lord victim. Lord.
No, the
I
main,
think there are some differences, in fact.
no, my lordship, all are equal. One,
No,
My
no, all
lord,
are
there
not equal.
There are 5 persons, my lord, who have killed.
Yes.
2 persons, there are my lord, this present petitioner, my lord, Songja Rongpi, and my lord, one Bibison Rongpi, my lord. And they were behind the bar, they are behind the bar till now, my lord. Other accused person maybe, my lord, Probin Rongpi, Ramsina Rongpi, and Mukrang Terang.
Mukrang Terang was the main conspirator.
Yes, my lord, they have conspired, my lord, among them, but these
As
these
per-
two
as
accused
per
person, they have
the-
killed, my lord.
Investigation.
They have killed the victim, my lord. Which
Case
will-
is already charged sheeted one.
All
Yes,
it is
started,
charged,
my lord. Now the next date
But
was.
these are, these
Next step-
orders are most probably prior to charge sheet or what?
My lord,
I think it is
Sarchi
prior,
submitted, my lord, Sarchi submitted on 18/1/2025, my lord.
18/1. Obviously, these are prior to charge sheet, in fact.
Maybe full base, my lord.
Yes, prior to search it, my lords.
Prior to charge.
Prior to search.
So now you have received this scan copy.
Yes, my lord, and there are sufficient materials, my lord, incriminating materials
My
against this, against this present petitioner, my lord. So I oppose this bail application.
No, but what is the stage of the case at present?
The case is tomorrow, my lords.
No, no, tomorrow is okay. Mane for production only,
For
or for
production and
evidence and all.
For hearing on charge, my lord, consideration of charge.
Consideration of charge.
Yes.
It's a case that one girl was killed. na?
Yes. Full-blooded murder, my lord.
Yes, yes. So how many of them were charged sheeted? 5.
Five.
My lord.
One was discharged.
The father.
Father
Father
was
was
teacher.
teacher.
The father, I have seen the case there. There was no such material against the father, but I don't know these two were granted as they have submitted also. But reason though I don't know at all.
But also my humble prayer is that I will
It was only under the length of detention. It was prior charge sheet, I think, as far as I remember.
Yes.
One, it was 82 days.
Yeah, 82
It
days.
was only considering the length of detention, only those were the bails were granted, I think.
The trial for first, mother frames are mother after that mother.
50
Because
witnesses.
Now one is it was father was granted, I think.
First father was granted.
Yes.
Next,
Harsing Teran.
yes,
He was the father. He don't know such evidence against
He
father.
had some illicit relation with
Illicit
the victim,
relations,
my lord. That is
yes.
why, my lord, his son, my lord, they have made a conspiracy, my lord.
Yes.
And my lord, they hired this, my lord, two person, my lord. One of the person is the present petitioner, my lord. They were paid, my lord, and thereafter, my lord, they killed the victim, who is just about 23 years old, my lord. And there are two eyewitnesses, my
Brutally
lord.
murdered she was.
There are two eyewitnesses, my lord, the sister and brother, my lord. So my humble submission, my lord, until and unless these two eyewitnesses are examined, my lord, I oppose this bail appeal.
Eyewitnesses, among the eyewitnesses, one is her sister also,
Sister and brother, one is brother.
because they were staying in the same.
My lordship, 50 witnesses are there.
No, I am not saying, my lord, he have to wait for examining 50 witnesses. But at least, my lord, the eyewitnesses has to be examined, my lord. If they are released on bail, my lord, before examining the eyewitnesses, my lord, then may, my lord, hit and the, my lord, witnesses, my lord, and hampering the trial.
So your petitioner is behind the bars since when?
It's 21/10/2024, 155 days.
155.
Till today, my lordship.
A very serious nature of case. In fact, there was a.
Will appear, my lordship. And there is no chances of tampering with the witness evidence, my lordship. Already more than 5 months and 50 witnesses are there. Considerable time will be taken.
At this stage, I am opposing, my lord, that the victim, the eyewitnesses be examined after this.
And tomorrow there is some CC is there, my lordship.
If required, my lord, that is bail application be kept pending, my lord. Subject to my another thing.
It can be otherwise. But for examination of, as you have submitted for examination, those eyewitnesses, it will take some considerable time.
My lord, they are the main witnesses, my lord. They are the main witnesses.
No, I'm not on that. So keeping this pending, that's what I'm saying.
My lord, that part I leave it to Lord.
What do you want to say? Other way, we can keep it pending for at least for some days. There may be some other development also regarding the appearance of witnesses, charge, framing of charge. This can be, they may be there, but what you have said.
Maybe then after, my lordship, after Bihu.
We'll fix it after Bihu.
After fix.
By that time, there may be some development also.
Yes, yes.
With the consent of the, any request made by Learning Council for both the parties, lady matter be listed. After Bihu, want any date here?
Date maybe fixed, my lordship.
28, 28/4. Take some considerable time, otherwise same position will be there. By the way, we call for the scan copy. In the meantime, the registry is further directed to call for the updated scan copy of the case record along with the present status report. Okay, only the present status report of the case. It will cover only present status report. And in the meantime, if it is within your knowledge that in the meantime, any witnesses are being examined, you can also file before us the certified copy. So that will also do through an addition. If we do not get the copies of evidence, suppose.
Yes.
In that case, you can file the certified copy if these two witnesses have been examined. We'll see to the matter.
Must have-
Otherwise, it's a very serious kind of nature of offense.
yes.
I mean, the murder was very brutal, in fact.
Yes.
A small girl.
I'm not on the merit of the case, my lordship, but it will take considerable, the 50 witnesses are there.
Okay, sure.
Must have.
People.
This is bail application for 83.
in connection with Rongia case number 23, 2025, registered under section 61 to
The service completed, my lord. LCR has also come, my lord. Yes, some amicus be appointed.
Services completed.
Yes.
It's a case of POXO.
But as per FIR, my lord, POXO case does not come into light, my lord. I may be permitted to period the FIR.
No, but yes, obviously, FD may not be there, but it's a charge sheeted one. No. Is still under investigation.
Investigation, under investigation, my lord.
No,
One
but
of
the question is that in every bail application or
Yes,
at
madam.
any stages of the bail hearing or every hearing,
Yes, my lord.
the victim has to be represented by someone.
Yes, my lord.
So now Mr. Burwa has submitted the services completed.
Yes, my lord.
So your petition is behind the bar since when?
Since 5/2/2025,
5/2/2020.
48 days till date, my lord.
It's a 90 days, I think.
If that section comes, 90 days, my lord. But as per allegation made in the FIR, that particular section does not come, my lord.
Yes, where is the FIR?
Because only thrice. My lord,
Mm.
সন্মানপূর্বক বিনীত নিবেদন এই যে যোৱাকালি ইংৰাজী 3/2/2025 তাৰিখে গধূলি প্ৰায় 6 মান বজাত মই ঘৰলৈ যাবৰ বাবে হাউচ চকত গাড়ীৰ বাবে ৰৈ থাকোঁতে উপযুক্ত পৰ্যটক কেইজনে মোক সিহঁতৰ গাড়ীত সোমাই লোৱা আৰু মোৰ লগত বেয়া কৰ্ম কৰিব চেষ্টা কৰে আৰু প্ৰহাৰ কৰে। উক্ত কৰ্মখনিত তেওঁলোকে মোবাইল ভিডিঅ' কৰি লয়। উপযুক্ত পদক্ষেপ কেইজনে উক্ত ভিডিঅ' ভাইৰেল কৰিম বুলি মোক ব্লেকমেইলিং কৰি মোৰ লগত থকা মোবাইল ফোন, সোণৰ আঙুঠি এটা, ৰূপৰ চেইন এডাল, ৰূপৰ ব্ৰেচলেট এডালৰ লগতে নগদ 400 টকা কাঢ়ি নিয়ে। আৰু আজি ভিতৰত নগদ 20,000 টকা নিদিলে উক্ত ভিডিঅ' ছ'চিয়েল মিডিয়াত আপলোড কৰিব বুলি ভয় ভাবুকি দিয়ে। উক্ত ঘটনাটো মই পুলিচক জনালে প্ৰাণনাশৰ ভাবুকি দিয়ে। My lord, on the other hand, FIR has been lodged by the victim child himself. And in the forwarding report submitted by the police, annexure 2, my lord, he has noted in his reporting number 3, the age of the victim is yet to be ascertained for further follow-up action.
Where from you're saying this thing?
In the forwarding report, my lord, annexure 2,
Achha.
page number 17, my lord. And on the other hand, one of the two accused person has been granted bail by the learned special judge, Kamrup Rongia, by the order dated 19 February 2025. That has been also annexed, my lord. 17 number ways. Oh, my lord, I'm sorry. Annexure number 5, page number 28, my lord.
And it's okay, we are not on that. The question is only that representation of the respondent number 2. That is the only issue. Burwa, yes, so it can be fixed. He is behind the bar most probably 48 days. So when it can be fixed now? Friday, to not possible.
Monday will be holiday, mother.
Yes,
Monday holiday, yes.
No, Monday is 31st, mother. I'm sorry, mother. Monday is holiday, yes. Monday is holiday.
Monday is
Then,
holiday.
mother, 1st of April.
1st of April.
If it is possible, my lord, on Monday, Friday, maybe, my lord, already the petitioner is the only son of his family. He earns his livelihood. His mother has been seriously suffering from some ailment, undergoing treatment in CMC, etc.
Sir, কিয় পাৰিব জানি? Case আছে fix কেনেকে পাৰিব? টাচে নকৰিব, ৰিচে নকৰিব। পাৰিব নেকি চাওকচোন, তাৰপিছত পাৰিব। All are insisting on Eid, na? That's why.
If possible, Friday.
Friday for fixed attendance. Hard sense of it is submitted by Mr. Borba that the service is completed on respond number 2. However, no one has appeared before the court. Accordingly, he submitted the amicus may be appointed to represent the respond number 2. Registry is accordingly. No, we can type when amicus find a name of one amicus. Yes.
MK Brown.
M.K. Brown. Accordingly, MS M.K. Brown is hereby appointed as an amicus to represent the respond number 2. Registry will inform the learned amicus accordingly. CD you have received, no?
No, madam, case diary not received, madam.
It is what?
It
At
was
what
called
stage?
for case diary, madam.
Huh?
It was fixed for case diary, madam.
It received.
Not received, madam.
Then
Case
wherefore
diary-
you are saying that on Friday it has to be
Friday,
fixed.
madam, case diary may come, madam, Friday.
Issue reminder for case diary. List accordingly on 28. We are just listing. It may not reach also. Huh? 28 to 4 to 20.
May I please, my lord? Page number 22. The ganja which was recovered from my house, from the petitioner house. The petitioner has been he was arrested actually on the 2nd of February, but on record on 3rd of February. Now, as of today, it's 54 days in the jail.
Case diary not received, madam.
2 kg, 836 grams. Actually, it was only 1 kg that they have written here, 2 kg, 836 grams, my lord.
It was an intermediate.
Yeah, it is intermediate. Actually, it was less than intermediate consumer only, and that was brought for the this Shivaratri purpose only. So if it is intermediate of 60 days, it's just near another couple of days only remaining, my lord.
You are in custody for 54 days.
My lord. And in fact, my wife who complained to the police station, she ran away, she left my house.
Huh? She?
Yes, the complainant, actually, here the informant is police. My wife and husband, they had a fight, they had a quarrel. So wife rushed to the police station and informed to the police saying that there is a contraband in my house. That is
Oh.
actual fact. Then the police
But
came
he
and
brought the entire contraband for Shivaratri only.
no, it was not he, not the petitioner, the villagers they brought. 1 kg something only, it is written it is written in the page number 22. One containing suspected to be a cannabis, that means 1 package was there, small package. So that is the fact the wife went to the police station complaining that
Madam, 2
My-
kg, 836 gram, madam.
yes, it's just above the consuming amount.
2 kg.
No, 1 kg is the
How one
consumer.
can consume 2 kg?
Yes. No, I'm saying 1
It
kg.
will be
It
near
was
about 3 kilo, madam.
Hmm?
Near about
Near
3
about 3
kilo, madam.
actually less than it was 1 kg.
Anyway.
Whatever it is on record,
Yes,
2
yes.
kg and the fact is that only wife complained. So police, they came, they arrested me and now petitioner in
You
jail.
should not be arrested because it was brought for only Shivaratri, no? That's why.
My lord. Entire that area. So this is
Yes,
my,
Borwa, he is in custody since last 54 days.
my,
52
Sorry?
days.
54 or 52, he is saying 50.
He was arrested on 2-2.
yes, on 2-2 he was arrested, but on record it's 3-2.
No, whatever, he is in custody since when?
Since
2-2. 2-2.
2-2.
2-2 হলো তো
Even
তাহলে
from
26
2
দিন।
to also, madam, today is 52 days, madam.
26 January, February. I think it is 26, 25. 52 days.
52 days. Okay.
Anyway, 52 days considerable period, but if CD is not available, you just may make an inquiry regarding the submission of the charge sheet.
Fine.
It may be fixed, maybe on Thursday, Friday, whatever.
Fine.
Maybe on Thursday,
Fine.
make an inquiry. We'll just make an inquiry regarding the hard sense of origin. Mr. Borwa, CD not received, issue reminder. In the meantime, Mr. Borba, the learned
My lord,
additional
he has got
PP.
some inconvenience.
No, I have to go to Itanagara on 27 and 29, maybe fixed on second.
Second.
2nd of April.
My lord, yes.
Okay, 2nd of April. 2nd of April, কেতিয়া? আন্টি নোট হয়ে যাবে নাকি 2nd? না, কিউ দিছি?
It will be 60 days, by the way. 2nd of April, you will be completed 60 days.
First, you can come. You'll be there at Arunachal for 27 and 28.
20 days, I have, 2 days I have a matter.
2 days you have matter, 30th and 31st is also in between. You're going to stay there or
I'll be, yeah, I have some work after my court matter, I have my. some
your
domestic-
personal work?
Personal work, my lord.
No, it's up to you if you can
It
fix
is
it.
on to 2-4 only, my lord.
Okay, then 2-4. In the meantime, the learned additional PP will all make an answer regarding this, the furnishing of the mechanical as to whether the charge sheet has already been filed in this case or not. Okay, we'll make it.
55.
May please, your lordship. On page 8 is the FIR, your lordship. This lordship might remember, madam, this came up last week, madam, on the 21st. Lordship was fixed it today, madam. I have taken the plea of the grounds of arrest, madam, that your learned friend, madam, not him, another learned friend was there, madam. He insisted on the case study. That's why, madam, the page 20, madam, page 8 is the FIR.
Page 8.
Page 8 is the FIR, your lordship. That case where some messages were sent, madam, to a lady's mobile. Madam, some vulgar, madam.
Messages.
Obscene messages, madam. If he is arrested, madam, 21 days in custody.
So basically you're stretching on the ground of arrest.
Grounds of arrest. And madam, detention 21 days, madam. Some messages were sent from his mobile to the, madam, to the lady's mobile, madam. Informant mobile, madam. So further custody may not be required, madam. And from morning, I've seen lots of learned advocates have submitted, madam, the grounds of arrest, madam. I don't want to, I brought the judgment, madam, but I don't want to submit now, madam. Page 22, madam, I have annexed the certified copy of the, madam, the notice, madam.
You are in custody for 21 days.
21 days. 21 days and page 22, I have the certified copy of the notice, madam. Notice under section 47, madam. What even dealt with since morning, madam, just Kavi Pukasya and others, madam. So, certified copy, madam. Here no grounds of arrest has been assigned, madam. Detention, madam, and madam, that grounds of arrest has not been assigned, madam. And further custody may not be required, madam. He has learned
Your
something-
mobile is already seized?
Seized, madam. Mobile.
Otherwise, madam, it is pending for FSR examination. That's
FSI
particular.
examination.
And allegations are true, my lord.
Otherwise, allegations are true.
Allegations are true, madam. Vulgar messages were forwarded to the mother to informant, madam.
Hmm. It is from the case diary.
Yes, madam, it is in the case. madam.
Okay, then. Yes, any other submission?
Madam, that submission, madam, that the grounds of arrest were not assigned, and madam, detention period, madam, detention 21 days, madam. And then lordship, madam, page 22, madam, the section 47 notice, madam, only notice was served, madam, nothing, and even 48 no notice, madam, in section for the relatives also, there was nothing was mentioned, only that arrest was, madam, was given, madam. So why he, madam,
23, it was issued to the relatives.
relatives, madam. There also nothing has been said, madam. No grounds of arrest, madam. I'm a local resident, madam. Run sufficient lesson, madam. On any stringent condition, madam. I pray for bail, madam. And If Lordship permits, but Lordship has to from judgment. I don't want to submit to judgment for public process.
The other day you have already submitted.
Yes,
Two
yes,
are
ma'am.
here with me.
Yes, ma'am.
One Prabhu Purkaste and one Hari Kishan is also there.
The answer
Yes.
whereas, my lord, that it is already, he has annexed, my lord, page number 22, my lord. You have been arrested so and so in connection to Azara police station case number so and so under section so and so, my lord.
That much only. We have actually sent some circulate some orders of this court also
That is
to DGP and to Home Secretary Home, in fact, to do the needful.
Nowadays they've started, my lord.
We have
They're
also,
starting.
Started my writing,
Yes.
my lord.
we have also, my lord, requested them to, my lord, at least, my lord, specifically mention the. grounds of
Otherwise, we are not only anything, but the question is that suppose some serious nature of
Yes,
offense.
Lordship is correct.
If there is a requirement of further investigation may also be required. It depends upon the merit of the case, but only on that ground. Now see, even after the observation of by the learned Honorable Apex Court, same mistakes are being doing.
Lordship.
So that is the issue. Anyway, I'll pass the order.
Lordship.
Dispose of, my lord.
Yes, it will be disposed. So we made a formal effect, that's why I'll pass the order in the chamber.
Document kindly allow it, my lord.
Let us see.
No, no. Oblige your lordship.
Thirty-five and 36.
35 is along with 36.
35, 36, my lord, this both accused person is on interim, my lord. But the case there is not up to date, my lord.
Yes.
I do not know, my
Your
lord, my
counsel is-
latest
it is-
is waiting for this.
Yes, I have seen Mr. Chaudhary also, she was waiting.
Yeah, because we are fasting, madam, so naturally we are.
Yes, yes.
Some
Now
tracks-
time is your
No, time is there, madam.
Time is
5:37 today, madam.
5:37.
Anyway, madam.
My lord, there are also some other cases, my lord, because he's a, I thought that he's
No,
waiting for this.
Another item.
With all respect, my lord.
No, no.
It was not
No,
my
no,
intention.
no. He has not seen me, madam.
He was busy doing with the
Yes,
file and all.
I
he
was
has not
behind
seen.
him, madam.
Anyway, same order লিখে দিব, CD not received.
No, case that he received.
Oh,
my lord.
sorry, updated you want?
It is not up to date, my lord. Please.
Case diary received, however, it is লেখো গোটেইখিনি লেখো। এই দুইটা একে order হ'ব হা। Heard Mr. H.R.S. Chaudhary, Deelani Senior Advocate, assisted by Mr. S.S. Ahmed, and also heard Mr. R.J. Borba, Deelani Additional People, so and so. It is submitted by Mr. Borba that the case diary is received, but it is not updated one, accordingly paid for, and accordingly paid to call for the updated one. Present CD may be accordingly returned, calling for an updated case diary. I full stop, I is hereby directed to furnish the case diary on or updated case diary on or before the next date of listing. When it can be listed then?
2-5, man.
List the matter accordingly on 2/5/2025, and till then, the interim will be extended.
Both the cases.
Yes, both the cases. Both the cases same order. Huh?
My lord.
37.
Perhaps CD is not available. Matter may be.
Yes, does CD? Are you on interim then?
Yes.
You are in interim?
Yes.
CD not received, issue reminder. List when it can be listed? April.
Since interim is there, lordship. On 22nd.
22nd of April, 2025. Interim be extended till next date of listing.
Much.
39.
One office notice here, na?
My lord, this case, my lord, several litigations are pending between the parties, lordship, since 2019, lordship. Kindly see before going to the FIR, lordship.
No,
My-
no, no, just see. One office notice here. Stays received and it is noticed. Yes, what is this stays position?
First, I want to state it is a POXO case where notice has been issued.
Notice was already issued. And here it is received by your office also.
No, it is there, lordship, it is received.
No, it is.
No, it is what I have informed from the office, lordship. On 21/3/25, it was taken away from the office, lordship, by the postman. But I have not received any report, lordship. that whether has been received or not.
No, from your office, it was taken back.
Taken away, lordship by postman, 21st/3/2025, but the service is awaited, lordship. I have not received it from the IO, lordship, whether it has been received or not. However, CD is there.
Oh, yeah, CD. Yes, CD is there. So if you make an inquiry, then we can fix at a date. Otherwise, it will be after Bihu only.
Lordship.
Can we be written CD?
I have
It may
seen,
not be,
lordship,
may not be possible.
otherwise, lordship, materials are there.
No, it's okay. We are not going to hear the matter because we are waiting in the case of POXO, I think. That's fine.
Then I will take on lordship on. Before view. Before view on.
It's because it is a section 6 POXO.
Lordship, on 10th or 9th of April. If possible, lordship.
We are not protected, lordship.
No, you cannot be protected. There's a POXO, no?
My lord, it does not mean, my lord, the interim may not be granted lordship. My lord,
No, at every
if
stage of
materials are
getting,
there, lordship.
every
I'm not
stage,
paying today, lordship, because my lord, for fixing short date, lordship. I'm not
you
fixing.
don't have any dates. How can you fix a short date?
My
You
lord,
don't have any dates.
April, lordship, before Bihu, lordship, maybe fixed, lord.
Before Bihu, we don't have.
Yes.
9,
lordship,
10, he
yes.
is suggesting 9. 9 is before Bihu only.
Lordship, yes.
Why are you insisting on that? For short date, we cannot accommodate everyone with a short
Why,
date
that
before
will go,
Eid,
lordship.
before Bihu. We cannot. No?
My lord,
How can we?
that will go.
It's not possible. দিব পাৰিব 9 বা 10? 9th. Heard Mr. M.H. Ahmed, the learned counsel for the petitioner, and also heard Mr. K.K. Dance, the learned additional PP, appearing on behalf of state respondent. And it is the steps from the office note, it is seen that the steps have already been taken by the petitioner. Accordingly, Mr. Dance, the learned additional PP, is hereby directed, hereby asked to make an inquiry regarding the service of notice on the respond number 2. CD received, retain the CD till next date of listing. List accordingly on 9/4/2020.
Oblige, lordship.
For orders 40 and 41.
This case, my lord, bail pending criminal appeal, my lord. Three accused were my lord convicted. One accused 10 years, other 5 years, 5 years, my lord. They already got bail, my lord. The condition of work court. So the present there was convicted under section 376, POXO, my lord, is there. So, and 10 years punishment, my lord. My learned friend, she is appeared amicus curiae, my lord. So, your lordship, my only prayer is, my
The
lord.
state has already filed their any objection here.
I don't think, lordship.
No.
it is,
No.
Objection not to any file, my lord.
So you're going to submit
Last time,
verbally?
my lord, there was, last time I think they have taken some time, my lord.
Last occasion.
Last occasion, no? Because
I don't know who has taken
Oh,
the time, lordship. I was not there at the
I
time.
have been told my junior, my lord.
But lordship,
Iqbal Hussain নাম করে আছে, what was it?
time দিব।
Huh?
Time টা দিব লাগিব, লিখি রাখি।
ঠিক আছে?
Last occasion, Ms. Saikia was appointed as an
Yes,
amicus for
am-
2 and 3. And memo of appeal was also directed to furnish and raised
Oh, yeah,
to
that was
reflect the
given.
name of so and so.
So about objection, nothing is there, government side. Yes, one is whatever.
Registry was accordingly directed to prepare a paper book, but I don't know whether paper book is ready.
No, that, paper otherwise not required also, my lord, because we will give all the copies, my lord, so far as the position are concerned. Single bench, my lord, paper
No,
book.
but
nothing.
we, I am not on that, that without preparation of paper book, the matter will not be heard, but I'm not on that,
Yes,
but
yes,
it's just
yes.
thinking a paper book is not ready. Now, the question is, I don't know who took time anyway, in the entire process is, well, itself, it is,
Since it is 10 years.
yes.
lordship, we have to file, lordship. Since it is punishment is 10 years, we have to file, lordship, that is why. We have to file.
Saikia,
objection.
you are also going to file
No, lordship, I'll make oral submission.
oral submission.
Lordship, if it is possible, one prayer is Lordship. Can it be after Bihu vacations if possible, Lordship?
Chaudhary will object, but it will go after you only,
Um,
because we don't have any.
I'm not saying before Eid, my lord, I'm not saying the view, my lord. Your lordship already fed up with this, my lord, submission.
Yes.
I'm not saying so, my lord. Because.
So you want any fixed date here,
if
or
possible.
after 2 weeks, what to do? Yes,
After
does.
2 weeks, we can do.
After 2 weeks.
After 2 weeks we'll do.
I will
Or we'll file leave the them immediately after Bihu vacation.
Right.
That will do immediately after vacation. In the meantime, you file your
Lordship,
things.
I will definitely.
Sure, my lord.
No, I will definitely.
Please follow up, Masla.
Heard Mr. H.R. Chaudhary, the learned senior advocate, assisted by Mr. M.I. Hussain. Mr. M.I. Hussain, and also heard Mr. K.K. Das, the learned additional PP appearing for the state response number 1, and MSD Sakya, the learned amicus for the response number 2 and 3. From the office note dated 20/03/2025, paper book is not ready. However, accordingly, the registries have directed to prepare the paper. Next para, further, Mr. K. Das, the learned additional PP, submitted that he needs some more time to file the written objection. Written objection
For the purpose of bail, because objection with regards to bail.
Objection in regards to this IA2, huh? IA bracket criminal 1076 of 2024. Prayer allowed. List the matter accordingly after 2 weeks. Immediately list the matter immediately after Bihu vacation, enabling the state respondent number 1 to file the written objection, if any. List accordingly.
Well,
Okay,
in the meantime, we'll file the deposit copy of the deposition of both of them. my lord.
Oh, you have not received
No, I have given copy, memo, the copies of the deposition and file will be given to her.
to amicus?
Yes, yes.
In the meantime,
Your lordship.
yes, in the meantime, the Mr. Chaudhary will supply all the relevant documents, including the evidence of the PWs, etc., to the learned amicus appearing for the response number 2 and 3.
So that might have bail, fixed for consideration of bail, my lord. Otherwise, again,
It will
paper.
come on order column, then
Oh,
the
order-
matter will be heard. That's why we're not fixing it on
I
for.
hope if lordship is there, certainly, my lord. I don't know.
41, Mr. Nawaz is.
Already on bail, my
Already there. Same matter, my lord, same matter. So,
Then what to do with same arising?
Yes.
Tag, my lord, it will come out.
Yes, yes.
No order is required.
A to
no?
40 लिखियो, first order to a second order 41 out. Heard Mr. S. Nawaz, the learned counsel for the appellant, and also heard Mr. K.K. Das, the learned counsel, learned additional PP for the state respondent. Matter may be tagged along with criminal appeal number. Already tagged. So and so. Oh, okay, it will be listed.
My stay remains meaningless.
Pardon?
My waiting remains meaningless, man.
In both the matters.
Both.
Both the matters.
Anyway, I enjoyed your lordship. All right.
So
It's a
item
42.
42, 42, the person was convicted under section 366 and 372, IPC, 7 years conviction, appeal has already been admitted, LCR also received, but I am still, IA is there for bail,
I is not here with us now. Today I is not fixed. Not listed. He is convicted for how many years?
7 years.
Now behind the bars since?
Since date of judgment, date of judgment is 4/10/2024. So far evidences are concerned, not supported by even her husband. He stated something else, husband stated something else, and informant is the mother of the victim. She also has stated something, different story. And IO statement is also there, I have annexed all those documents. So may I pray, any date, convenient date, your lordship's convenient, because person is behind the bar, unnecessarily to my understanding.
However, lordship, as per order dated lordship 28/11/2024, steps need to be taken But as per office note 4/1/2025, no steps has been taken, Lord. It will, 42. তাতে এটা কিবা এটা আছে, note এটা আছে। As per office note dated 4/1/2025,
4-1.
Lordship, 4/1/2025, office note.
এটা LCR হে আছে আপনার call for LCR.
তাতে কিবা এটা পাইছিল আপনি।
Because there is no private respondent.
No private.
No private respondent. Yes.
তাতে দেখিছিল তো আপনি।
Not.
I had to go.
I need to make,
Oh, I know,
I have to for bail.
I know.
State is the only party, I think.
Yes, okay, Lord.
Well, as the matter that the IA is not.
Regarding the LCR, one LCR we have received. yes.
LCR received.
Okay, then we can hear the matter also.
Well,
I mean, no, not I, entire matter can be heard, I think. If it is no thing is there, but just now see what to do. Today is also Tuesday, but lots of matters have been fixed, so hearing is ultimately, it won't reach hearing. That is the main issue we have now facing. So then,
if possible, my lord, 10th, my lord, if possible. my lord.
no, not at all possible. Not at all.
I am praying for only my lord, IA, my lord, that is.
Not at, your eye is not listed today. in
That is
fact.
why, my lord, that is why, my lord.
I, what is the number of I?
Yeah, my lord, 1186, my lord. IA criminal
I
1186.
criminal 1186 of 2024.
24.
We could heard Mr. N.K. Kalida, the learned counsel for the appellant, and also heard Mr. K.K. Das, the learned additional PP, appearing on behalf of state respondent. List the matter after vacation along with IA criminal 1186 of 2024. Further from the office, further it is seen that the LCR has already been received and case is also ready for hearing. List accordingly. Okay, we'll list it along with IA criminal 1186 of 2024 after 2 weeks.
My lord, I am praying for only death, my lord, because it is very difficult nowadays, my lord, to got the matter listed. I am only praying for death. Any death. my lord.
Before be subject. 6-5. It will be come under month of May only, 6-5. 6-5
That
at
is
best, yes. 6-5. Okay.
43.
May I please, Your Honor? As per office note, Lordship, LCR not received, and also step could not be taken, Lordship.
He could not take steps.
Lordship, so further time may be required, Lordship. LCR also,
How many respondents are there? Private respondent number 2.
number 2.
You are Mr.
RL Sutia.
Heard Mr. R.L. Sutia, the learned counsel for the petition, and also heard Mr. K.K. Das, the learned additional PP, appearing on behalf of state respondent number 1. From the office note, it is seen that the LCR is not yet received. Further, it is submitted by Mr. Chutia, the learned counsel for the petitioner, that inadvertently he could not take steps on the respondent number 2. Petitioner next para, the appellant is accordingly directed to take steps on the respondent number 2 within 2/3 days. The registry is also hereby directed to issue reminder to call for the LCR. List accordingly after 3 weeks, it will be listed.
Lordship, Sublime.
44.
Not appellant,
Make
petitioner.
legal
no?
lordship.
Appellant. Yes, 44.
Lordship, office note dated 21 March, Lordship, 21 March, indicates that Lordship, scan copy has been received, Lordship, from the lower court, Lordship,
We require scan copy or LCR total?
LCR.
LCR. But scan copy you have received. Case is pending, I think, no?
Lordship.
So we have received the scan copy. And the,
Lordship,
you have already appeared,
Yes, on behalf of the respondent number 2.
respond
Lordship
number
will
two.
file the wakalat number just today. Kindly then a few time may be given, Lordship will file a reply.
You file a reply.
Lordship, a short date may kindly be given because evidence, next date fixed for evidence on 21st, Lordship.
No, we don't have any short
Immediately
date.
after reopening of the BU vacation,
We'll try.
Lordship.
You are Mr.
I'm R Islam.
R. Islam. Heard Mr. R. Islam, the learned counsel for the petition. Also heard Mr. K. Das, the learned edition PP, so and so. Scan copy from the office note dated 21/3/2025. It is seen that the scan copy has already been received, which is already tagged with the case record. Further, you are Mr.
N.J. Daimari.
N.J. Damari has already entered into evidence for the respondent number 2. He accordingly submitted that he has filed his wakalatnama today and need some more time to file their written objection. Prayer allowed, this matter accordingly. It will be after BU vacation,
And then a date may kindly be fixed. That
28/4.
Oblige.
46. My lord, the IA is for delay, continuation of delay of 33 days, my lord.
How many days? 33 days.
33 days.
Yes, state is here, party, no.
No, my lord. Private party, only the respondent is there, my lord.
In that case, too, otherwise we could have passed the order hearing the
Yes,
petitioner said you have to issue notice.
yes, yes.
Issue notice for hard koro. Hard MS NS Takuria, the learned counsel for the petitioner applicant. Issue notice to the how many respondents? Sole respondent.
Only one.
So notice to the sole respondent through registered AD and as well the process. This matter accordingly, after 3 weeks will do, you take steps within this
Yes, yes.
list after 3 weeks. Okay, we're listing it after 3 weeks, take steps within 2-3 days.
My.
Thank you.
Oblige, my lord.
Oh.
For hearing, item 47.
Wait, please, Your Lordship. Lordship, in this matter, I have received the paper book today, which Lordship members had directed. My lord will fix it after, my lord, immediately after the BU vacation, my lord, we'll in the meantime, I'll go through it properly, my lord.
In this case, my lord, online submission I have.
You are for the respondent.
Amicus curiae.
Oh, amicus. Acha.
My lord, as on today, my lord, petitioner is behind the bar 2 years, 5 months from the date of conviction. And total out of 5 years conviction. My lord. More than 50% he is already over, my lord. And during the trial, almost 3 months.
Okay, do one thing. I can understand he is behind the bar for more than 2 years. So now paper book is ready. He is seeking some little accommodation, but obviously it will not be prior BU. It will be definitely will come.
Prior BU,
No,
possible.
not at all possible. Not at all possible. That's what I'm saying.
My lord.
It will be definitely after BU. And just
Immediately after BU, possible. 21, my lord.
21 is a hearing day.
Hearing days.
Hearing day, not hearing day.
21?
21 is not a hearing day, my lord.
Hearing day.
22.
22, my lord. Then 20.
22 is a hearing day. No?
Yes.
You are for the appellant.
Appellant.
You are Mr. Azad, no?
AK Azad.
AK Azad. Heard Mr. AK Azad, counsel for the appellant. And also heard Mr. A. Fukan, the learned amicus, applicant for the respondent number 2, and Mr. KK Das, the learned additional PP for the state respondent number 1. Paper book is ready and it is submitted by Mr. Fukan that he received the paper book today and accordingly needs some time for preparation for preparation of the case. Considering expera, considering the submission made by the learned amicus curiae, let the matter be listed accordingly on 22nd of April, 22/4/2025 for hearing. Just do one thing in the morning hours, just remind us about once. Because now see question is that if you give him the listed the last one, that's why.
Last almost 2-3 days gone on that way, my lord.
Hmm?
Last almost 2-3 days gone on that way, not reached properly. And last, I have to make mention due to Deepika is my senior. On that day, on morning, I will remind her.
Also, the copies were not served also in wrong.
Yes, yes,
that's
wrong.
why-
copy.
There is-
Okay, we're listing out otherwise on a hearing day, that is on 22nd.
My lord,
Thank you, Abhay.
much obliged.
Thank you.
48.
It is already 4:15. It will take some time.
Yes, sir.
Hussein will also take some time. It is the problem we are facing what to do. And Parthard is more dangerous because Parthard is what is that I may have a bench in the outline bench,
Yes,
then
yes,
it
yes.
will again drag. So Parthard is
Mhm.
also a problematic. So it is a cumulative petition of 2022, na?
22.
Due to paucity of time, the matter could not be heard. Will be listed immediately after vacation. Date cannot be given, I think.
Lordship.
Date and not. After vacation will do.
That lordship may kindly give a date,
Hmm.
any date to the convenience of your lordship and kindly make it part heard.
Parthard.
Parthard.
No, Parthard will be a problem for you only.
Because
When in the month of May, see the date.
8-5.
8/5. Okay. We're fixing it on 8/5. Okay.
Obliged.
49.
Lordship, the engaged counsel, Mr. D. Goswami is on legs. I am not in this case, so kindly fix this matter on other date.
No, one hand you are saying he is on legs, and on the other hand you are saying fix another date. Man, what means I could not follow you.
Can it be
Mr.
taken on
Goswami is on legs.
legs?
Now it is 4:15. What will it do?
Session.
The sessions code.
I am not in the case, that's why I must.
Yes, Mukherjee, it will be, we don't have any time also.
I understand.
Like,
We don't have, I will not insist on a date, but I have a small prayer, your lordship. There is no stay in this case, admittedly, but the LCRs have been called for. For that matter, this is maintenance
But
is,
LCR is a scan copy, I think.
no, original was called for. That is
Why?
it.
Why original was called for?
There was
It
an
should
order.
not be. It is a maintenance case.
Yes, your lordship.
So
The
maintenance case,
scan
generally
copy
there
may
is no
be-
stay error.
Yes, lordship. Scan copy can be retained and the original can be sent back, then I don't have any problem. There can be an order.
So now the registry will do these things. Enter original has come. But we have received this original copy
There was
when?
an order, your lordship, 18/9/2023. Perhaps.
We have received this one on 18/9.
Order was passed on 18/9, your lordship.
Number itu kita pasu ba?
It's from May 2023. And
Oh.
it's on this.
So you have not brought this matter before the court? 223 since 23 the case record is here.
If
क्यों
it is-
क्यों did original case record to?
Can be sent
It's
back.
a maintenance matter.
Yes, your lordship.
Then-
DV matter, your lordship. Maintenance and contract.
For DB matter, maintenance matter,
Yes,
we
yes.
generally do not pass any order on stay. In fact, on the first day also, they most probably it was passed by this court and we didn't pass any order on stay because it is not the view of us there to it. And how May 25 order was on 18/9/23? How the record can be sent on May 23? Because it is the order of September 2023.
Yes.
Then
Maybe it was received in connection with some other matter.
was there any other matter also?
There is another matter. which
Oh,
relates
that is
to-
there. That is the question. Yes. But that
That
in their case,
125. 125.
that is also 125.
Yes, your lordship.
Now, keeping the scan record and all, it will again create a problem. In fact,
In fact, this original may be sent back with a direction to send the scanned copy back. I'll not insist on a date, short date, because it will take time to send back the records and send the scanned copy.
but the original is also tagged with the other case,
No, no,
125
That is released from that case.
released.
Yes.
Acha. So you are Mr.
NK Kashyap.
NK Kashyap appearing on behalf of Mr. D. Goswami, the counsel for the petitioner. And also heard Mr. B.J. Mukherjee, the counsel appearing for the respondent number 2. due to paucity of time, the matter could not be heard. However, it is pointed out, it is submitted by Mr. Mukherjee that though there is no stay order operating in this case, but the original case record is still lying in the court in the event of since 2023, and hence no order could be passed in the learned trial, could be passed by the learned trial court below. In view of this, the registry is hereby directed to make a scan copy of the record and to send back the original record before the concerned court to proceed with the matter. List accordingly after 2 weeks. Okay.
Item number 42, my lord.
Hmm.
I have wrongly referred my IA criminal 1186. It should be 1126, my lord.
1126.
26.
Luciano 1186 is it? Paisano 42 to 1126 na 1126 koi diba
My lord,
1126.
instead of fixing it on 6, can it be an earlier order after 2 weeks, my lord?
Now you are insisting on date fix. Okay. Anyway, yes, 50 already did. Watch it.
This is already.